My, hello?
Yeah, I'm here.
My attorney said, he can't make it today. For some reason, he said he had COVID or something.
Uh-oh. Okay,
I don't know.
well, this is what I'll do. I'll invite you into the Lakeshore Legal Aid lobby, and maybe they can help you or give you.
Your Honor, I'm sorry, Your Honor, this is commercial property. I'm sure they probably can't help him.
Oh, this is a commercial property, Ms. Sawyer?
Yes,
Yes.
yes.
Well, thank you for letting me know that, Ms. Sawyer. Yeah, they will not assist you today. All right, well,
And I'm
I
not
know.
interested in an adjournment. I'm sorry. My apologies, but I'm not interested in an adjournment.
I'll call a case. I'll call a case shortly.
Thank you.
I'm not an adjournment judge.
Hello, Your Honor.
Attorney Sabree, and then I'll take the phone caller who so count. Okay. All right, who just chimed in on the phone?
Hello, how you doing, Your Honor?
Doing well. Good morning.
I'm doing pretty good. I was on the phone with with the lawyer, and she had started talking about some stuff that I didn't know nothing about. And I asked for legal aid, and I never got to legal aid.
All right, I'm going to put you in the breakout room. It's the Lakeshore Legal Lobby. Please be patient because someone will eventually come and speak to you.
So just stay on the phone.
Catch him while you can, Mr. Keeney.
Thank you. Did you catch his name? Just so.
I think he's with case number 6294, Great Lakes Renaissance versus Otha Hurst. He's speaking for his father.
Got it. All right. Thank you.
Well, Attorney Moore, good morning.
Good morning, Your Honor. I'm needing to speak with, I'm here on one case, 233-44448.
448.
Yes, sir. It's
This is Attorney Fawaz.
we filed, Your Honor, there's a companion case with this. This property has an upper and lower unit. We filed a stipulated order to consolidate those cases in front of Judge Sherman, because that's where the other case is, and it's the older case. And I don't know if it's reached Your Honor yet.
All right, let's see. I'll check the file. Let's see. 4448. 444. Fine. Okay, I don't see anything in here. Was it sent over recently, or what? Has it been a while since it was sent?
No, it was just sent over on Monday, Your Honor. When we had the other case in front of Judge Sherman, the parties agreed to when we had the companion case in front of Judge Sherman on Monday, the parties agreed to stipulate to consolidate, so I submitted the order on Monday.
Okay, all right, well, I have no issue with consolidating this case. Parties have already stipulated to it, so let's see. Can you email it to me?
Absolutely, Your Honor. Where do I send the email?
I'll send it in the chat. And then
Thank you, sir.
Once I see both signatures, I mean, I believe you, but I like to see
Absolutely.
that. And then I can just, we can just order that it's consolidated. That should do it. I think the clerks know how to do the magic.
Thank you very much, sir.
Okay, hold on one sec.
Sure. Sheree Kipling, you can disconnect and I'll be in touch with you. That's the person issues on this case.
Okay, and let's see, attorney Moore. Okay, that should work. And then just pop a hand up at some point, Attorney Moore. And yeah, give us a minute or two, and then I'll call it. Is this your only case in here?
Yes, sir.
Okay, so just let me know when you email and I'll call it as soon as you email it.
Thank you.
All right, go. Need to grab something out of the chambers, and then we'll call some more cases.
Your Honor,
Yes, sir.
is there any way I can speak to an attorney? This is Luther Holtz.
Luther Holtz. All right, let's see. Luther Holtz.
Hello?
Are you an owner of commercial property? Is
No,
this a
sir.
commercial issue? I'm going to invite you, Mr. Holtz, into the Lakeshore lobby. Someone should talk to you. Click accept. And Mary Ann Robinson, good morning.
Good morning, Judge.
Good morning. Are you checked? I see you are on case 6338. You're the plaintiff on 6338.
Yes,
Okay. Did you have a resolution or a question for the court?
did you, yeah, he talking to you? Yes,
I have you checked in.
Judge, can you speak louder? I can't hear good.
Do you have a question for the court?
Yes, do you have a question for the court? Yes, I want to know if I can get my son to get out of here because he doesn't pay bills and he got 3 children and he's been here over 10 years, sir. Is that a question?
That's absolutely a question. My answer is we'll call your case shortly, and we're gonna give your son until 9:30 to check in
Yes, sir.
before I call it default. So if he's here, then possibly we could earlier, but at the least 9:30 would be the cutoff time.
Your Honor, don't mean to interrupt. Could you put myself and Johnny Marsh in a breakout room?
You said Johnny Marsh.
Yes.
Good morning, counsel. And I gave you breakout privileges. I'll still put you in room 5, but you should be able to move around as you need.
Perfect. Thank you, Your Honor. I appreciate it.
Well,
Judge Sabree, good morning, sir.
morning, sir. How are you?
I'm blessed. I was on at 8:30. I'm be honest, 8:32, but I was on Zoom and it wasn't connecting, so I had my hand raised in the chat. You never called. Excuse me.
Okay. Do you want to legal aid, or are you just trying to check in?
I was just checking in. That's all.
All right. What case number are you on?
233-46261. Bragg.
Okay. Are you the plaintiff or the defendant?
I'm the plaintiff. I'm sorry.
Okay.
I'm the plaintiff. I'm the plaintiff.
Okay.
Sorry.
I have you checked in. And then
Thank you, sir.
you're welcome.
Good morning, Your
Attorney
Honor. Good morning, Your Honor. Godwin Maduka here.
All right, good morning. I have you check in too, under 6304, Mr. Maduka.
Well, thank you, Your Honor.
Welcome. It's Christopher Porter here. Is Christopher Porter here? All right, Attorney Sabree.
Yes, Judge, I have 2 ready.
Fantastic. 2 cases, and both cases are ready to go.
Thank you.
Okay, calling case number 2334-6310. This is Rose Community Management versus Deidre Davis.
Good morning, Judge. May it please the court, Mark Wasbury, P51575 for plaintiff.
Thank you. Deidre Davis.
Yes.
Good morning, Ms. Davis.
Good morning.
All right, were parties able to work out a resolution?
Yes.
Miss Davis indicated she needs 10 days to pay or move. She plans on moving. The total amount is due is $15,964, which includes court costs of $188. I explained to Miss Davis her 10-day right to appeal as well as the 3-day rule. And Miss Davis, do I have permission to sign your name to those terms? The money will be due by May 22, or you will vacate by that day.
Yes.
All right, the court is satisfied. Good luck, Ms. Davis. A writ of eviction could issue after May 22nd. So
Okay.
it's either pay or vacate by May 22nd, or a writ of eviction could issue.
Okay, thank you.
You're welcome. You have a great day. Have a good
You
weekend.
You too.
All right, and is that a consent? We entering that as a consent judgment, counsel?
Yes, Judge.
Okay, and you did get consent, so
Yes.
it's a sign. All right, court is all right with that. Calling case number 2334-6311. This is Prince Sargent versus Eric Bolden.
Again, Mark Wasbury, P51575 for plaintiff, Judge.
Thank you. And Mr. Bolden, can you state your name for the record?
Eric Bolden.
All right, thank you, Mr. Bolden.
Judge, we have agreed on a conditional dismissal, 30 days to move. We will check box 4B. So 30 days puts us at June 21, Your Honor.
All right. You are agreeing to vacate by June 21st, 2023. You said June 21?
Yes, Your Honor. Oh, I'm sorry. That would be June 11. It's
right.
30 days out. Thank you, Judge.
Okay, we'll do June 12th. Let's do June 12th.
Okay.
That's a Monday.
Okay.
You almost got another week or two, but this matter be dismissed if Mr. Bolden, if you vacate by June 12th, 2023. In the event that you do not vacate by June 12th, 2023, then Attorney Wasbury can apply for a judgment and an application for eviction at the same time. We won't have to go back to court. But in the event that you vacate, your matter is dismissed. Do you have any questions?
No, Your Honor.
And do you give Mr. Wasbury, because you all aren't in the courtroom, he can sign your name instead of sending it over, you signing it, mailing back to him. So do you give him consent to sign your name? Do you give Mr. Wasbury permission to sign the agreement with your name on it based on that we discussed on the record?
Oh, yes, Your Honor.
Okay, all right, the court is satisfied. Good luck, Mr. Bolden. And thank you, counsel.
Thank you,
Good
Judge.
luck.
Take care.
Well, take care.
Bye-bye.
Run and grab the file. If Madam Court Reporter, can you try to check in a few unknown names?
I sure will.
I know G. Madhu is really the plaintiff on 6304. That's Godwin Maduko.
Yes, Your Honor.
We're gonna change your name, and then there's a few other people in here. So let's see if we can chip away at it a little bit. And then I'll be back in 5.
What's that name again? GMADU?
Godwin Maduko.
Let's go over to 6304.
Okay, 6304. There's a person signed in under Zoom user. What's your name for court? Zoom user, unmute your device.
Is it for 304?
No, we have you already, sir. Thank you. You can mute your device.
Me? Is it for me? My name is Brittany Douglas.
Brittany Douglas. Say something else, Miss Douglas.
It's Brittany Douglas.
Okay, give me a second. You under the wrong person. And what time is your matter today?
My court date was at 10:45, I believe.
Okay, let me see.
I think it was 10:45.
We don't have a 1045. What's your case number?
I don't know my case number by heart.
Well, how are we supposed to find out who you are, Miss Douglas? You don't have no paperwork?
No, I just got the Zoom paper.
Well, we don't have any cases scheduled for 1045. Who were you with on your last matter? What judge?
Demetria Brew. But this is my second hearing, so they sent me over here.
Mr. Nevels, can you help?
I'm with Forest Park Apartments.
I don't know.
Sure. What's your last name?
Douglas.
And first name?
Brittany.
She don't know her case number.
Okay. And spell your first name.
Brittany.
I don't see anything.
I have a whole case.
She said she was a judge. Who were you with last time? Kennedy?
Demetria Brew.
Oh.
Okay, there it is. I see it.
You see it?
Yep, you're still with Judge Brew today at 10:45.
Oh. So I just log back into her courtroom at 10:45.
Or before then?
No, you can do it
log back in now.
Faster. Yeah.
Yeah. If I was you, I would.
Okay.
Okay, bye.
Bye.
And while we're waiting, is it possible that a couple Lakeshore staff members can get co-host privileges? Are you guys able to do that?
Sure. I think Mr. Nevels can help you guys out.
Yeah.
Sorry, he took my privileges away.
No problem. All right, we'll try to tackle that when he gets back.
C. Belfour. There's a C. Belfour on here. Okay, let's move on to the phone number ending in 1368. 1368, unmute your device. Phone number 1368. Okay, the young man with the glasses on at the top, what's your name for court?
Travis, Carl Travis.
Charles Travis.
No, Carl Travis.
Oh, Carl, I'm sorry.
I was already on, but it got kicked back off for some reason. I don't know.
Okay, so if you get kicked back off, come back in with your name on, because I can't keep renaming everything.
Okay.
So I'm gonna rename you again, Carl Travis. Unmute your device. Okay, and when the judge come back, they'll get you back in the breakout room.
You got me named that Carl Travis?
Yep, and when they come back, when the judge come back, they'll put you back in you were in the breakout room?
No, I was on with the judge.
Oh, okay, well, you on with the judge now, so he'll be back shortly.
It's still saying Balford on there.
Well, give me a second.
Oh,
And it's
okay,
the
okay.
judge, okay?
I'm sorry.
That's okay. Carl Travis, 300. Okay, you can mute your device.
All right.
Thank you.
You're welcome.
Alrighty. There's someone signed in under KJ. KJ,
Yeah, that's me.
what's your name for court, sir?
It's Keenan Jackson, Keenan.
Wait a minute.
Jackson.
One more, give me a second.
Okay.
Spell it again, K-E.
Keenen.
K-E-E-N-E-N.
No, Keenan.
I got it. What's your last name?
Jackson. Jackson.
And what's the last 3 digits of your case number?
It's 643.
643?
Yes, ma'am.
Okay. Okay, you can place your device on mute. The court will be with you shortly.
You say place it on mute?
Yes, until you hear your name called, and then press unmute so the judge can hear you.
Okay.
Okay, thanks.
Yeah.
There's a person signed in under Zoom user. Zoom user, unmute your device. The person signed in under phone number ending in 1368. 1368, unmute your device. Okay, they don't want to be heard today. Let me see. Maduka. Zoom user. Again, there's a person signed in under Zoom user. Alicia Woods. Is there Alicia Woods on? Mr. Robert Moraninsky. I'm sorry, I know I pronounced it wrong. I can't hear you. Unmute your device. Oh, you have to connect to the audio.
I'm Alika Woods.
Oh, I'm sorry, Miss Alika Woods. What time is your matter today in front of Judge Adam Sabree?
9.
9 o'clock. Give me a second. Let me see. Do you know the last 3 digits?
Yes.
You read 9 on the docket today.
It's a motion for eviction.
In front of what judge?
Sabree.
What's the last 3 digits of your case number? You said it's at 9 o'clock?
Right.
Okay, yep. You're in the right courtroom. You can press, you the plaintiff. You can place your device on mute. The court will be with you shortly, Mr.
Okay.
Okay, I think I can hear you now.
Okay, okay, turn your TV down or whatever you're listening to so the court can hear you.
That is not me.
Oh, okay, I'm sorry. Okay, what's your name? I see your name is Robert. I don't want to check your name.
Mrozinski.
And what matter are you here for?
It was for an eviction, and I was just looking at this email because I was trying to get the
What's
case.
the case number?
That's what I was just looking for on my email. 233-45183.
45183.
Yes, and I just realized I could be in the wrong room.
Yes. And who's the judge that's on your paperwork?
It says Dimitri Abreu.
Okay. Mr. Nevels, can you give him that?
Yep, it says June the 2nd at 8:30 in front of Judge Sabree.
Oh, you hear that, Mr. Marinsky? June the 2nd.
Is what has been changed to June the 2nd? Because I thought it says today on this paperwork.
Yep, your case was in front of Judge Dimitri Abreu today, and it's been adjourned to June the 2nd at 8:30. You can sign into Judge Brew's courtroom. They can verify that if you don't believe us, but yep.
I mean, I do believe you.
And so, Mr. Nevels, he come back here on June the 2nd with Judge Adam Sabree?
Yes.
So June the 2nd is your next court day, sir.
Okay, and that number is 360-432-0000.
No, it's, oh, June the 2nd. Oh, no, it's, 436. What you in today? You and Judge Adam Sabree's today.
Okay, very
But
good,
it's-
thank you.
But it's June the 2nd, Judge
Yep.
Adam Sabree.
Yes, thank you very much.
Okay. Have a good day.
You too.
Bye. Thanks, Mr. Neville.
No problem.
Let me see, who we got next? Zoom user, there's a person on here by the name of Zoom user. Amelia Jackson. Jackson. Unmute your device, Miss Jackson.
Hello,
Oh, good morning. What's your name for court?
Geronda Robertson.
Okay, give me 1 second. You on the phone number ending in 8568?
No, 8821.
Well, I see 8568 for your phone.
Oh yeah, yep. That's right. That's the right number.
Okay, and what's your name again? I'm sorry.
Geronda Robertson.
And what time is your matter, or do you have the last 3 digits of your case number while I'm looking at it?
The time was 8:30.
8:30, Robertson.
Yeah.
More assertive in your conversations. Number one, stop over.
I have an Eddie Robertson at 8:30. I don't have a Geronda Robertson. Do you have your paperwork?
Yes, I have it.
What's the judge's name on your paperwork?
McClinton.
Yes, you're in the wrong courtroom. This is Judge Adam Sabree.
Okay.
So you have the login number for there?
I can hear you back.
Do you have the login number for Judge McClinton? It should be on your
No.
paperwork. Okay.
At the top?
Yes.
No.
Mr. Nevels, do you have Judge McClinton number to dial in?
It's 431, so you want to switch 436 with 431 instead.
She's on the telephone.
Oh, shoot. There's 360-431-0000 when prompted.
Okay, thank you.
You're welcome.
Okay, thank you.
All right, I'm going to call.
Judge, excuse me, before we get started, can we have a couple staff members from Lakeshore get breakout room privileges?
Sure.
Yeah. Brittany Mackey, Carla Valdez, and then Hervé. I think that should be everyone. I sent you a chat, so you have their names.
And if I missed you, just put your hand up. And then Attorney Datz and then Attorney Samad.
Yes, Your Honor, we have a consent judgment on our case. I don't know if you want to go on the record on that 144.
Absolutely. Whatever's ready to go, I will call it. Let's see. That's
It's probably under Piper.
All right, calling case number 2-334-5144. This is 855manager.com LLC versus Johnny Marsh and Tanya Madison.
Good morning, Your Honor. Craig Dates on behalf of 855. And Johnny Marsh and Tanya Madison are on the Zoom call in the same room together on the same device. Your Honor, we reached a consent judgment for the amount of rent owing of $4,660 plus June rent of $800 plus court costs of $155 for a total of $5,615. I have given the defendants we have agreed upon a vacate date, pay date of June 30th, 2023, and the parties waived the 56-day rule. They were explaining their rights on the Michigan court rules. And they gave me permission to sign on their behalf.
Okay. All right, do you understand this agreement, Mr. Marsh and Ms. Madison?
Yes, sir.
All right, this is a consent judgment where $5,615 must be paid on or before June 30th, 2023. Parties must either make that payment or vacate. There's a waiver of the 56-day rule, which if this judgment will be entered today, but 56 days later, if a writ is filed on the 56th day or the 70th day, the court will still allow for the writ to be filed without an additional hearing. Are parties aware of all of their rights and the terms of this judgment?
Yes, sir.
All right, the court is satisfied. We'll enter this. Thank you, counsel.
Thank you, sir.
Have a wonderful day, Your Honor. Thank you. Paul, you can hang up too.
Thank you, Craig.
Attorney Sean?
Ready, Your Honor.
Okay, are you ready on, is it 294?
That one, I believe that the tenant may be in with Lakeshore. I'm only going to request an adjournment for that one. So I'm ready on all three.
Okay, I'll just go in order. Calling case number 2334-6293. This is Great Lakes Renaissance versus Lauren Fleming and all occupants.
Good morning, Your Honor. Marlene is shown for the plaintiff P69505.
Thank you. Is Javon Weems, oh, I'm sorry, is Lauren Fleming here? Lauren Fleming. Does anyone reside at 9932 Lawton, Unit L9? There's one person in the waiting room. Let's verify and make sure. A1 is not Lauren Fleming. All right, it's Lauren Fleming. Lauren Fleming. Counsel, you may proceed.
Your Honor, requesting a default judgment. The rent to retain is $34.92, and then $160 in costs comes $36.52. Requesting a default judgment.
All right. Defendant failed to appear. Is Lauren Fleming here? All right, and I see God's is signed in. Doesn't look like Lauren Fleming. Default judgment is granted. Defendant must pay $3,652 by May 22nd, 2023, or writ may issue. Must vacate that amount.
I'll submit that proposed order. Thank you.
Calling case number 2334-6294. This is Great Lakes Renaissance versus Otha Hurst.
Good morning, Your Honor. Marlene is shown for the plaintiff P69505. I'm just requesting an adjournment on this one, Your Honor, until early June, if that's possible.
All right, let's see. Lakeshore Legal is here on Tuesdays and Fridays.
You'll be in person on that.
We'll be in person after June 5th. Just FYI.
Oh, is that across the LT docket, Your Honor?
Yes, it is.
Okay, thank you.
So we can go virtual. We can do it last week of virtual. We can do the first week of in person.
I think, is it possible June 2nd? Would that be possible?
Yeah, we can do June 2nd.
Okay.
Do I have any cases?
We do 5.
Okay, kind of like docket. Let's come in at 8:30, June 2nd.
Thank you, Your Honor.
And I'm sending a message to the attorney that's with Ms. Hurst to get that information, so they will know.
Okay, and if you all, Ms. Sean, do you have the other side's information?
I don't. I'd like to know who's helping.
Okay, Mr. Keenan, can you message Ms. Attorney Sean? We have
Yeah,
one more.
I'll check with Attorney Connor Brown to see if he's going to represent that tenant and have him contact you.
Thank you.
Thank you. And lastly, we have case number 2334-6295. This is Great Lakes Renaissance Properties versus Javon Weems and occupants on Alter Road.
I'm Monique Burrows, but Javon Weems is currently at work. I'm also at the property. I should be on the docket as well.
Yes, you are on the docket as Monique Burrows. All right, Ms. Monique Burrows, do you have an attorney?
No, I do not.
Okay. Attorney Sean is here. She's here right now. Would you like to speak with her? She's the
Yes,
attorney for.
I'm happy to meet with her, Your Honor.
All right, and put you all. I think you can go back to room 4 without an invite, Ms. Sean.
Let's try.
Your last name? Counsel?
Thank you.
You're welcome. All right, after that case, Keisha Sawyer and Carl Travis are here. So I'm ready to call that matter. But allow me to get the defaults in. So I'm gonna call Mr. Saman, then I'm gonna call Mr. Marchese. So the attorneys from the 8:30s, and then I'll call this case. So you probably have 5 or 10 minutes, Mr. Travis and Ms. Sawyer, just to get a heads up. All right, Attorney Saman, good morning.
Good morning, Your Honor.
Have you talked to Ms. Wilson?
Yes, I have, Judge. We have a resolution.
Fantastic. Calling case number 2334-6282. This is Montpal LLC versus Shanae Wilson.
Yes, good morning, Your Honor. William Simon on behalf of the plaintiff 80352.
Thank you, Mr. Saman. And Shanae Wilson, can I have your appearance for the record?
I'm sorry, Your Honor, I didn't hear you.
Can you state your name?
Shanae Wilson.
All right, thank you, Ms. Wilson.
You're welcome.
All right, Counselor, what terms did you all agree to?
Judge, we agreed that Ms. Wilson will pay her move by I believe it was June 12th. The amount due owing as of now is $6,642.60. We would like to ask court to enter a judgment by hearing, and against all occupants only. We will dismiss Ms. Wilson from the case.
All right, and is that your understanding of the agreement?
Yes.
All right, so this would be a judgment by hearing. Defendant will pay or vacate by June 12th. If you decide to pay, the amount is $6,642.60. Okay. Shanae Wilson is dismissed as the named party. This judgment will enter all occupants. So good luck, Ms. Wilson. You have your marching orders. Have a great weekend.
Okay, thank you.
You're welcome.
Thank you, Judge. Thank you, Ms. Wilson. Yeah.
You're welcome. Bye-bye.
You're welcome. Is Genoa Chambers here?
Excuse me, Your Honor.
There you go.
Can you guys hear me?
Are you Mr. Chambers?
No, my name is Devontae Brantley. But what I was trying to say is the phone is about to die. When I got my tablet, I just want you guys know I have to call back in.
You need to get a charger. What case are you on?
You said what, Your Honor?
What case are you on? And stop driving, please. Don't get in an accident.
I'm not.
No, I need you to stop driving, but I don't want you to get in an accident trying to stop driving. But
I'm a little over around to the side.
okay.
My case number is 223-96130.
And is this a traffic matter?
Who?
What matter is this? This landlord tenant or is this traffic or a criminal?
Landlord tenant. This landlord tenant.
Okay, I saw a blue sheet. Mr.
Yeah, I'm under all occupants.
Okay, you're all occupants. What's the address?
Yeah. Yes, not yet.
Or Ardmore?
Yes.
Okay.
Okay.
Judge, this is the emergency motion to
It's
stay.
okay, it's emergency motion to stay the proceedings. With Alicia Woods. Okay, I have you checked in with Ms. Woods. Do you all want to talk?
Me and my landlord.
Yes.
I will speak to her. I don't think she's gonna speak to you though. I really don't. I try to talk. I don't know if she wanna talk.
All right, well, let's rename, you're in all occupants, you're on case, what is it, 042? 552? All right, thank you for letting me know who you are. And you have I'll call your case shortly. Just try to get to wherever you're trying to go. I'm trying to get a charger. That's what I suggest.
Okay, thank you. Thank
you. All.
Your Honor, I'm ready with Ms. Burrows when you are.
Okay. Calling case number 2334-6295, Great Lakes Renaissance Properties versus Javon Weems and Monique Burrows.
Good morning, Your Honor. Marlene is shown for the plaintiff P69505. I've reached an agreement with Ms. Burrows.
All right. Ms. Burrows?
Yeah.
Good morning.
Good morning.
All right, and what is that agreement, counsel?
So, Your Honor, Ms. Burrows is here, so it would be a consent against Ms. Burrows, a default against Mr. Ween. So the total amount owing in rent is $4,096, and then $160 in costs. That comes to $42.56. I've given Ms. Burrows until May 31st, just almost 3 weeks to pay that. She understands that amount would need to be paid in full. If she pays by May 31st, then I will dismiss the case, at request of the court vacate the judgment.
Okay. If paid by May 31st, the judgment will be vacated. And as to Javon Weems, who failed to appear, are you requesting a default judgment?
Yes, Your Honor.
Okay.
And I explained the 3-day rule.
Okay. Now, is this default judgment? Okay. Would it be the same move out date?
Yes, Your Honor.
Okay. Okay, the court will enter this. Ms. Burrows, do you have any questions at all?
Will it still be a default case against him even though he has to do the work and I'm here on the same household as me?
He failed to appear, so it would be,
I would dismiss against both parties, Your Honor. If they either pay or move by that date, I will dismiss against both parties.
all right, Ms. Burrows, did you understand that?
Yes.
Okay. So he will be defaulted today for non-appearance, but the same terms apply to both of you all. So if you pay or vacate by May 31st, both judgments will be vacated.
Okay, thank you.
Good luck. You're welcome. Have a great day. Thank you,
Thank you,
counsel.
Your Honor. See you back on the 2nd.
All right.
Yeah, Sabree, can I ask you a question?
Sure. Another question, for sure.
I'm just making sure I'm listening to the back and forth call. I'm just making sure I'm still in rotation. I ain't get skipped over, did I? It's Mr. Bragg. 261 case number.
Yeah, you're unrepresented by counsel, and your cases usually take longer than the ones that have attorneys.
Okay.
So attorneys, and then
Okay.
I follow cases.
Okay,
But
just for checking.
you're highlighted on my docket sheet, Mr. Bragg.
Okay, sir.
Highlighted, circled, and underlined. No smoking in court. Very comfortable at home, but we don't want to see you smoking, Mr. Travis. Please cut your camera off. You have a second. That changes anything. Attorney Moore, and then Mr. Marchese. And then Mr. Simon. Attorney Moore, you have anything?
Yes, Your Honor, I emailed the stipulated order.
That's addressed. Did you get it? Let's see it.
Excuse me, Your Honor, I didn't hear you. Were you talking to me?
I didn't complete my question. I'm looking for it.
I
but
do
don't-
that. Do you want to, you search by the case number? I did put that in the subject line.
One more solution. Can you send it there?
Absolutely, Your Honor. Doing it right away.
Okay. Attorney Marchese.
Yes, sir. I think the tenant's actually here in my matter.
Okay, is Jeree Henderson here?
He's in the gallery.
Mr. Henderson. Is Jeree Henderson here? All right. All right, Attorney Saman.
Yes, Judge, ready.
All right, and that's for Visionoa Chambers.
Yes, Judge, ending in 283. I'm ready on a default.
Calling case number. Is the Ms. Chambers? Calling case number 2334-6283. This is Maxmar 3602 LLC versus Visionoa Chambers and all occupants.
Yes. Good morning, Your Honor. William Simon on behalf of the plaintiff 80352.
All right, thank you. And does anyone live on West Margaret Street? West Margaret Street, anyone? Counsel defendant has failed to appear. Are you requesting a default judgment?
Yes, Judge, I am at this time. Defendant owes past due rent in the amount of $6,392 plus $160 in court costs for a total of $6,552.
All right, and that amount must be paid by May 22nd, 2023, or a writ can issue.
Thank you, Judge. I'll submit the order.
Right. You are welcome.
Have a good week.
You too.
Your Honor,
Attorney
I
Gray?
think, yes. Good timing. Can you hear me?
Yes, I can hear you.
Okay, excellent. I think Mr. Coleman and I are ready on a case.
All right,
That is affirmative, Judge. We are ready.
931 case, calling case number 2239394. This is Golden Key Real Estate versus Tamika Neal and all occupants.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff, this matter before this honorable court on a motion for issuance of writ of restitution to my understanding.
And this is Hillary Braley, P number 82889, here on behalf of Tamika Neal, who is here with us. Ms. Neal, if you can unmute and state your name for the record.
Tamika Neal.
Thank you.
Your Honor, it is, go ahead, Counselor.
Okay, I was going to say at this point, it is my understanding that Ms. Neal, you have vacated the property and it's, you don't have anything left there that you need to go get, correct?
Yes.
Okay. So
Your
at this
Honor.
point, Your Honor, it's our position that Attorney Coleman's client can have immediate possession.
That's correct. We're asking that the writ be signed, Your Honor, just to make sure there's no one in there, but understand that she's already moved out. So that's what we'd be
That'll mean a
requesting.
writ to be signed in my name then, right? There's still no,
Nothing is, we
Huh.
took it out of your name already. It's for all occupants. So
Okay.
anybody left in there, just to make sure that we don't run into a problem, Your Honor, we ask that the writ be signed as, you know what, I think the writ does have Mrs. Neal's name on it. If you can redact that, Your Honor, I have no problem with that.
Okay.
And that would obviously be our preference, please.
Okay, so the court will. I'll deny I granted the motion to set aside, but the issue is moot. Defendant is vacated. So I'll sign the writ. This writ was already signed. I'll redact Ms. Neal's name.
Your Honor, what date was the writ signed on? 'Cause I've never gotten a copy of it.
April 3rd, 2023, but it states that writ shall not be executed before May 1st.
Okay, that's fine, Your Honor.
So, and are you requesting a waiver of the 56-day rule?
I am requesting a waiver of the 56-day rule, Your Honor.
All right. Okay.
No objection.
Thank you much, Your Honor. You yourself and the gallery have a wonderful day and a better weekend. Attorney Brady, you know it's always a pleasure. See you next week.
Okay, sounds good. Thank you. Ms. Neal, I do believe you are free to go.
Okay, thank you.
Okay, thank you.
Attorney Warner. Good morning.
Good morning. I have two cases. Ready? I have one 8:30 that I believe the tenant has not appeared, and then a 10 a.m. that is being dismissed.
Let's go to 10 a.m. first. On case number 23346-538. This is Day by Day Property Management versus Andrew Beatty and all occupants.
For the record, Jessica Warner, P 84628, representing the plaintiff. We have filed a motion to dismiss on this matter.
All right, dismissal without prejudice is granted. Thank you, counsel.
Thank you.
Let's see if your tenant is here. Is John Oyer here? John Oyer. John Oyer. All right, counsel. Calling case number 23346-342. This is Renaissance City Club versus John Oyer.
Jessica Warner, P 84628, representing the plaintiff.
Thank you. And Mr. Oyer. Does anyone reside on Brush Street in apartment 2403? All right, defendant has failed to appear. Counsel, are you requesting a default?
Yes, Your Honor. To retain, we have outstanding balance of $6,426, court costs of $161, for a total of $6,587.
All right, defendant failed to appear. Default judgment is granted. Defendant must pay $6,587 by May 22nd, or a writ may issue. Pay or vacate by May 22nd.
Thank you, Your Honor.
Well,
Have a good rest of
all right, you too.
Oh. Keep coming in. Squares keep getting smaller. All right. Calling case number 2-334-6300. This is Keisha Sawyer versus Carl Travis.
Hi, Your Honor, Keisha Sawyer.
Good
Hi,
morning,
Carl Travis.
How you doing, attorney? I mean, Mr. Travis. Okay. Parties are here for a complaint for non-payment of rent for the property located at 8403 Harbor Avenue. So.
Correct.
Ms. Sawyer, are you the owner of the property located at 8403 Harbor Avenue?
Yes, Your Honor, I am.
All right. Is that property in your name?
Yes.
Okay. And Mr. Travis, are you occupying the property at 8403?
Yes, sir.
Okay. Nope. So this is a complaint for non-payment of rent. Do you have the total amount of rent that's owed at the time?
I do, Your Honor. At this time, the total amount rent due is $10,200.
$10,200. And the rental rate is $2,500 per month?
That is correct.
Okay. And are you objecting to this amount, Mr. Travis?
No, sir.
Okay. So I think it's this, the only issue is when can this amount be paid, or are there plans to vacate?
No, I want to pay. I want to pay, Your Honor.
Okay. All right. And Ms. Sawyer, how much time are you willing to give Mr. Travis to pay?
10 days, Your Honor.
Okay, that's the statutory minimum, 10 days, so I'll just count that as none. Okay. All right, Mr. Travis.
Yes.
As of right now, you're gonna have to pay $10,200 by May 22nd. Any reason you have any?
Can I have more time? Can I have a couple of more days than that?
I'll give you until May 26th. That puts you at Friday. And parties wouldn't be able to, Ms. Sawyer, you wouldn't be able to file a writ of eviction until May 30th. So that gives you a week.
It'll be paid by then, Your Honor.
Okay.
The 26th is good.
Okay. All right. So I'm going to do a judgment by hearing where defendant must pay $10,200 by, say, May 26, 2023, or a writ may issue. So a writ can be applied for Ms. Sawyer on that Tuesday, May 30th, in the event no payment or no move out. And Mr. Travis, if you pay or move out, then the judgment is satisfied and we have nothing to talk about in courtroom 436.
Thank you. It'll be paid by now, 26.
Okay, all right, well, good luck to both parties. Enjoy your weekend.
You as well. Thank you, Your Honor.
Thank you.
Glad I can get you all out of here.
All right, thank you.
You're welcome. Sheriff, let's see, Attorney Moore, let's double back and address this issue.
Yes, Your Honor, I'm right here.
Okay.
Judge, on this case with Frederick,
Attorney Moore, I still don't see this, and I'm starting to think it's not your computer, it's mine.
Did you check your junk folder?
I don't even know if we. I don't have a junk.
You don't? No, that's distressing.
I mean, it says it, but it's nothing in there. We can't check it anyway.
Oh.
All right, let's see. Let's see what's on the. Let's put it on the record. All right. Is the case on my is the case on my docket today, Attorney Moore?
Yes, case 233-44448 is on your docket for today.
This is Jamal Al-Zakari, Muhammad Jamal. Okay. Calling case number 233-44448. This is Jamal Al-Zakari Muhammad versus all occupants.
Good morning, Your Honor. For the record, Sharon Moore, P70411, Michigan Legal Services here on behalf of all defendants. Your Honor, the parties in this case have agreed to consolidate this case with a companion case, case number 233-44447, because both cases involve the same property, the same premises, then the same parties. And seeing as the other case is older, we are going to consolidate both cases before the Honorable Millicent Sherman in this 36th District Court. An order has been agreed to, stipulated and agreed to by the parties and submitted for signature.
Okay, and upon receipt, I do have a lot of documents to sign today, so it's probably in this pile of documents, but we are on the record. We will consolidate this matter, case number 233-44448 with case number 233-44447 to consolidate the issues and make it more reasonable for all parties, since the same issues and the same parties exist. So we'll combine this case. We're not dismissing it, but we're transferring it to Judge Sherman. Do you have the court date for that next one? If you don't, that's fine.
Yes, Your Honor.
What's that date?
That next date, Your Honor, is May 25.
All right, 2023. All right, I'll note the file and we can find it on the ROA. So thank you. And this case is consolidated with 44447. And for the record, as you stated, parties have mutually agreed. Both parties have signed a consolidation, so it's not an issue on that.
Thank you, Your Honor. Have a good day. Have a good weekend.
If I can ask what time is for, so it'll be together.
Attorney Moore, what time is the case scheduled for on May 25th?
I believe it is 8:45, Your Honor.
All right, thank you.
Does the court need me further?
Oh, no. Enjoy your weekend,
Thank
Attorney
you.
Moore.
Have a good weekend to you and your staff. Bye-bye.
Your Honor, Attorney Boyke, I'm sorry to interrupt. I was just curious if we had a next court date for a case from earlier today.
All right, what case is that?
It ends in the last four are 7365. Double check.
I don't see a 7365. 2334 7365.
Correct.
Yes. Is that for Luther Holtz?
Is that for Luther Holtz?
Correct, Your Honor.
Yeah, that's in Judge Akay's courtroom. That's in 538.
Oh, today it was? Oh.
512. It's in it's in Judge Akay. It's awaiting a dismissal.
Okay.
Defendant failed to appear.
All right. Thank you, Your Honor.
You're welcome.
Okay. Mr. Holt, I'm going to grab you in a breakout room for just a moment.
Wow, I've been 8:30 this morning.
Give me just 1 second.
Is Christopher Porter here? Christopher Porter. Is Mr. Dugo present?
Right here, Your Honor.
Okay, calling case number 2334-6304. This is Godwin Maduko versus Christopher Porter and all occupants.
Yes. Good morning, Your Honor. Godwin Maduko, plaintiff. The tenant to retain possession owes $4,006.35 plus court cost of $90 for a total cost of $4,096.35.
All right, and did you have this, who served this document, Mr. Maduko?
Myron Bell.
Myron Bell?
Yes.
Let's see. All right. Okay. And is anyone here from 1465 Helen Street? I'll let this phone caller, I'm gonna ask the phone caller. Caller just came in, are you Christopher
Hello.
Porter? Are you Christopher
No.
Porter? Do you live on Helen Street?
No.
All right. Okay, hold on one second, ma'am. All right, Mr. Maduka, are you requesting a default judgment?
That's correct, Your Honor.
All right, this is a non-payment of rent case. Defendant failed to appear. Default judgment is granted. Defendant must pay $4,096. That's 4096.35 by May 22nd, 2023, or a writ of eviction may issue.
Thank you, Your Honor.
You are welcome. All right, Miss.
Nice weekend.
All right, you have a great weekend as well.
Thanks.
Sign this, this is the attorney.
All right, Mary Ann Robinson, we're gonna call your case next. 1 second. Adam. Yeah. Where's the, what? She wants me to sign this, but there's no defendant's signature. There's no defense counsel signature.
People from the second.
Okay, yeah, well, ask them about that. All right. Signed it, but it's probably a duplicate that she didn't get the second signature on, but had on the first one, most likely. Oh. Let's see, okay. Thanks. You are the next case, Ms. Robinson. Is Clarence McCord here? Clarence McCord. I'm gonna call one quick case before yours, Ms. Robinson, and then you're next. Is Jaree Henderson here? Attorney Marchese, do we have a resolution on?
No, sir, he's still there. He didn't say anything before. I mean, it's going on 2 hours now. I mean, we gotta make a move with this one.
Oh, I see him at the bottom of the screen. Let's see if I'll remove him, and if he comes back, then it'll probably work.
All right, cool, thanks.
You're welcome. All right, Ms. Robinson, let's get you out of here.
Yes, Judge.
Calling case number 2334-6338, Mary Robinson Ann versus Eddie Lee Robinson Jr.
Yes, sir.
All right. Can you state your name for the record?
Mary Ann Robinson.
All right, Mary Ann Robinson. Good morning. Thank you for your
Morning to
patience.
the judge.
Good morning. Is Eddie Lee Robinson Jr. here? Is there anyone by the name of Eddie Lee Robinson Jr. present? Does anyone reside at 3902 Mitchell Street? All right, Ms. Robinson, what would you like the court to do?
What would you like the court to do? I would like for him to move out of my home with his 3 children as quickly as possible.
All right, defendant failed to appear. Default judgment is granted. All occupants must vacate. Eddie Lee Robinson Jr. and all occupants Must vacate by, let's see, May 22nd, 2023, or a writ of eviction can issue.
May the
Ms. Roberts?
22nd?
May 22nd, 2023. Now, Ms. Robinson, you are responsible for submitting a judgment to the court.
Would you repeat that for me, Judge, please?
You have to submit a judgment to the court. Make sure you submit a judgment and the court will sign it.
Oh, okay. How do I do that, Judge? Would you tell me?
Yeah, you can submit it. You can come down. It's on the second floor of 36th District. Just remember that there's a default judgment with the move-out date of May 22nd.
Okay.
And come down with your case number. Make sure you have your case number.
All right.
All
Thank
right.
you.
You're welcome. Have a great weekend.
Thank you. You do the same.
All right, thank you. All right, is Benjamin Shelley or Corey McKinney here?
Would you talk to me?
No.
Okay.
Mr. Henderson. Mr. Henderson. Attorney Zahner. Good morning.
Good morning, Your Honor.
Are you ready on your matter?
Yes.
Is Clarence McCord here? I call default judgments an hour after scheduled hearing. Are you requesting a default, counsel?
That's correct, Judge.
Okay, yeah, you still have some time. This is a 10 o'clock case. So I can call that 11.
Okay.
11, I'll call your defaults. Keep an eye out. Is Clarence McCord here? If it's a dismissal, I'll take it right now. But 11 is the magic hour for you. Attorney Pagani.
Judge, my name is Devontae Brantley. I'm not driving anymore.
All right, all right. You're all occupants on what's the case number? This is a motion. This is a motion that was filed. 655 Jeanette McLeod. That's not you. Do you have an attorney?
Me?
Yeah, where are you? Where are you in the Zoom? Can you say something again, please?
My name Devontae Brantley. I was just saying I wasn't driving anymore.
All right. You want to speak to an attorney?
Yes.
I'm going to invite you into the Lakeshore Legal Lobby. Carla Valdez, are you still waiting on breakout privileges?
Yes, Your Honor.
Excuse me, Your Honor, did you call Nanette McLeod?
I did. Is Vera Gezeraj here?
Yes, this is Vera Jerajai.
Jerajai.
Yes.
Hello, Ms. Jerajai.
Good morning.
I know a Koj, a Kochaj. So I was very proud. Jerajai. Okay.
Close.
Get that one. Would you like to speak with Ms. McLeod?
No, I think I'm okay.
All right, both parties are here. We don't have anything else ready. Let's call the case. Calling case number 6334-6552, Vera Jerajai versus Nanette McLeod. I have appearances. Oh, can you state your name for the record, Ms. Jerajai?
Hi, this is Vera Jerajai.
And Ms. McLeod, can you state your name for the record?
This is Nanette McLeod.
Thank you, Nanette McLeod. All right. And do you still reside on Nottingham Road?
Yes.
Ms. Jerajai, you own the property at 10612 Nottingham?
I do.
And is it in your name?
It is.
All right. This is a complaint. Let's see, who's Dawson, very noisy, Dawson. All right, this is a complaint for non-payment of rent. The rent is $700 per month, and right now there's an amount. What is the total amount due in owing?
Total amount right now is $6,300.
6,300. And do you remember paying for a money judgment in this case?
I don't remember.
Look, are you asking for a money judgment or just possession of the property?
I'm asking for a money judgment.
Is there a did you get personal service?
She did, by Myron Bell.
Okay. Can we confirm this money judgment?
What's the other case?
I just see it was pled for, but it's usually stamped, it says money judgment.
Actually, maybe I didn't get a money judgment, but I would like one or to file for one.
Hold on 1 second. It's 2334-655. Okay. It looks like the summons and complaint was posted. Getting a judgment today wouldn't preclude you from collecting your money in a separate action, but today this is a non-payment of rent possession only case based on service. So money judgment, you would need personal service, and it would have to be paid for at the time of filing. Now, it looks like it's pled, but it doesn't look like the box is checked. So let's stick to possession right now. Ms. McLeod, how much, is $6,300 owed? Do you plan on paying this amount?
Yes, I have some agents trying to help me, but they saying it's like 10 to 12 days because I have to get a judgment paper from you in order for them to release the money. And I was telling them that I go to court today, and they was like, we can't do nothing until we get something from the judge. I guess something from you today, saying how much it is, and they're going to take progress.
And is that SCR?
No, the SCR, they was giving me $620, then the other people was paying the rest.
Okay, so.
But they want the name and all that, so what they know what to do. They was telling me something about I need a judgment after I get through talking to you for me to get some type of paper from you or some type of number or something so they can look into it and go into it. But I wasn't really
They
understanding.
need your case number. And
Okay,
how much
wait,
time?
hold on, sorry, please. Thank you. Hold on. I was looking for my E-pen. Okay, the case number, I just give them this right here, right? 233465552.
Yes, ma'am. I was saying that they probably. Yeah, I was saying that they probably need your case number, but Miss Jerajai.
They was saying something from you, I guess, when you get the paper from you after you come from court.
Yeah.
But I told them I don't know how I can get it, but they said somehow you should be able to email it to me or text it to me, then I can email or text it to them. Because I told them that I go to court on Zoom.
Okay, all right, and you can always come up to the courthouse if you need to pick a copy of the judgment. It sounds like this is urgent, so that goes for both parties. If you need a copy of the judgment, we have it in person. You'll get it faster.
So ain't no way that's what I need. Ain't no way they can text it to me or email it to me so I can send it to them? Or you just want me to come up to the court to get it?
This is the thing, you all are both unrepresented parties. So I can enter the judgment for the reason you're in need of assistance, and time is of the essence of this. So I'll fill out the judgment. This will be, let's see what terms are. How much time are you willing to give Ms. McLeod, Ms. Jerajai?
I can give up to 3 weeks or whatever she thinks they need in order to pay.
Yeah, I have it. Trust me, I have it.
So 3 weeks will be June 2nd.
Okay.
Parties must, Ms. McLeod, you must pay or vacate by June 2nd.
Would you be able to adjust the cost, because by then your rent payment would be added, so it would actually be $7,000 if payment had to be made by June 2nd.
Yeah, but we can't do it. We can't put future costs on there.
Okay.
So, I mean, we can let's make it May 31st.
Her rental date is the 27th, so it's fine. June 2nd, whatever you think.
Okay.
Well, I can pay. I know I can pay about close to $2,000 by the 22nd. I mean, by the 28th. But I'm waiting on them. They was gonna pay it all. But if you want me to pay something, I'll be able to pay something by the 28th.
Well, just understand that if your funding covers this amount, you're still on the hook for June rent that isn't included in this balance.
Yeah, I'll be able to pay June. Yeah.
Okay, so the court will enter a judgment by hearing where Ms. McLeod, you must pay $6,300 or vacate by June 2nd, 2020. The court will enter this. The court will sign. I don't need your signatures because this is a judgment by hearing. And then Ms. Jerajai, you'll get a copy in the mail. Cloud, we can put a copy in the mail for you, but if you really need assistance, you could come up here this afternoon and pick up the judgment and get it over to who you need to get it to.
Okay, still put one in the mail, then I gotta wait to pick up my daughter, then I'll be up there. But if I can't get there today, I know I'll be there Monday morning, for sure.
We're gonna put it in the mail this weekend, because you only have one, it's a defendant copy. So you're gonna get it.
Okay.
So we'll make sure it's in the mail. It'll probably be there by Tuesday or something.
Okay, then thank you, sir. Thank you. Thank you, Judge.
You're welcome. All right, thank you. Thank you, Ms. Jerajai.
Thank you. I appreciate you filling it out. Have a good day.
You too.
Thanks.
You all have a great weekend.
Good morning, Your Honor.
Good morning.
How you doing? This is Luther Hopes. I just found out, I've been here since 8:30 this morning, talk to you, and just found out I'm in the wrong courtroom.
You did just like 30 minutes ago. You're an attorney, you're in Mr. JK's courtroom, correct?
I don't know where, this is the only courtroom that keeps popping up. I can't get to him.
All right, how are you getting to this courtroom?
I punched in your numbers that's on the paperwork that I got. For tablet on the phone, 360-436-0000, and I keep coming back to you.
That's because you keep popping. So change that 436 to 538.
The 436 to 538.
Yep, so all the courtrooms are those middle numbers. So he was in 436, he got moved to 538. So you might be working with the old notice or something, or maybe it was just a mistake somehow, but 360-538-0000 will get you Judge JK. No problem.
All right.
Take care. All right. And Mr. Marchese, seems like we.
Yeah, Judge. So I was in the breakout room, Mr. Henderson. I waited 5 minutes. I got tired of hearing myself say hello. Please turn on your volume. So I don't know if he's back in here now. Maybe he will respond. I don't know.
Hello, I'm right here. I couldn't get my volume to work.
All right. Okay. I go back in the breakout room with him now. That's fine.
Okay. So, all right. I can call it. We can just.
All right, that's fine. I mean, we might as well start there. Get this ball rolling somehow.
Yeah, let's just call it and get it on the record, because I don't want the audio to get. Calling case number 2334-6346, the Pavilion versus Sabree Henderson.
Dan Marchese, P 75872 plaintiff.
And Mr. Henderson, can you state your name for the record?
Sabree Henderson.
Your Honor, this is subsequent hearing on non-payment of rent. Landlord alleges inclusive of court costs. Total amount is $3,565.
All right. Is that the amount owed? Are you contesting the rent amount owed, Mr. Henderson?
All I needed was the actual amount, Your Honor. The paperwork that they sent me kept stating that it was basically a month's worth instead of the total amount of 3 months worth. And if I can just get the paperwork from the court saying that the 3,500, whatever the rest of it is, then I can actually send it off and pay them.
Okay, great. So it sounds like you can pay. I can send you a ledger. Maybe can you chat me your email and I'll send you a ledger? Can I do it that way?
The only catch is with my actual program that I'm in, they actually want to see a court document paper.
Like a judgment?
I'm sorry?
Like a judgment?
Yes.
Okay, Judge, I could do like June. I could give him 30 days at least, you know, if you want to do a judgment to help him out.
Okay, yeah, no problem. So we'll do, is this a consent judgment, 30 days?
Well, Judge, I would do an all occupants judgment, but if he's getting assistance, like, I don't know if that'll impact his assistance. So I'd be more than happy to set it aside later. So Mr. Henderson, you can contact our office once you get funding. So, you know, consent or after hearing, I don't know if it matters.
I don't know exactly what you mean.
No, Mr. Henderson, sometimes we put judgments in all occupants' names. The plaintiff's attorney, they know that if you have a judgment in your name, you might not be able to get housing. Your situation is different. You need funding. So we're going to put the judgment in your name. But he was saying, in the event all this is cleared up, 2 months down the lane, or 1 month, or whenever it's satisfied, he'll vacate the judgment for you. you contact his office, they'll set aside the judgment because it's water under the bridge at that point, and it's
Okay.
not. So, but right now, you need a judgment in your name. So,
Right.
consent judgment, parties agree to either pay or vacate. What is the total amount, Mr. Marchese?
$3,565, inclusive of court costs, which are $167.
Okay, so $3,565 is to be paid on or before June 21st.
Am I getting something in the mail with that whole total? Is that possible?
Yeah, if you leave Mr. Marchese your email, you can get an email of the judgment today.
Okay, I can do that.
Just chat that to me, please, before I leave, if you could do that real quick, thanks.
I need to sign it though, so put me on the, let's do this. Put me on the email. I want you all to get your assistance. So I forwarded this to the other side who was here right before you, and I'll do it for you as well today. But
Yeah, I can send it right now, so.
okay. And all right, so June 21st is the consent judgment. You are represented by counsel, so technically court rule MCR 4.201I applies, where you can file a motion within 3 days to set this aside if you decide this is the wrong decision. Looks like you're frozen, but I think you can hear me, and I'm glad we were able to get this done. Okay. Send it over. I'll
Thanks,
sign it.
Judge.
You're welcome. You're welcome. So that one and this one, we have to put judgments.
Yes, Judge, we're gonna do it right now too.
Well, Mr. Marchese, no, Mr. Marchese is gonna send it.
Oh, okay.
You email it, sign it, so he can get it back to us. And then this one we fill out.
All right.
Oh, Judge, I need his permission to sign. Did he leave? Fabulous. Sorry, I forgot completely.
Just send it on the email.
Well, I can't sign his name, so I need to submit it as a hearing judgment now. So I'll still send it to you.
I'll do it as a hearing judgment. Okay, yeah, still send it as a hearing judgment, and then I'll sign it, no problem. I think it's better that way anyway. Or when it comes to assistance. Seems like less of a choice, but. All right, we have a handful of Megan Hoff, there's some breakout privileges. All right.
Yes,
Ian
Your Honor,
Jackson.
thank you.
You're welcome. Keenan Jackson.
Yes, sir.
This morning. Jackson, you're on 643. Are you? Let's see, 643. I'm just trying to find you. Been in here for a while. I want to make sure we haven't called your case already. You know what matter? 643. Are you the landlord?
No, sir.
You know who the landlord is?
Well, let me rephrase that. I was the owner of the property, and I was, I lost the property for foreclosure, and I was trying to get a foreclosure recovery.
All right, so are you listed as occupants on the complaint?
It says all party, it says all occupancy, yes.
Okay, okay. All right, sit tight, we'll try to figure out. Give us your case number one more time.
It's 233-42643.
Sean Jacquet, Judge.
You're in Sean Jacquet's courtroom. That's 538. Courtroom 538.
Five, three, eight.
Yes, sir. Courtroom 538. Mr. Marchese, I received the email.
Very good. I realized he couldn't chat me his email, so I don't know how you want to handle that, but he'll get a copy, hopefully, but he can follow up.
We'll print it out. I'll print this out, sign it, copy it, and put it in the mail today, so I'm signing it right now.
I appreciate your efficiency. Have a good weekend. Thank you.
All right, you're welcome. Mr. Jackson, let's get you to, you got in here 360-436-0000. Take that 436, turn it into 538.
Are you switching me over?
No, I can't switch you over. The technology is not that advanced.
Okay, thank you.
You have a sheet. No, Mr. Jackson, before I lose you, you have a sheet that says has a Zoom code on it, right?
Yes, sir.
What's that Zoom code? First sheet.
It says Zoom, it says courtroom 436.
Right, but does it have a Zoom ID? I want to just make sure to give you. It's on the first one, on the right column, it says you are directed to appear at.
Let's see where.
This little X that says do not appear in person, needs to have a hearing. But I want you to get this number. It's 360-538.
Right. 360-538-40.
Yeah, that's where you need to be.
Okay, thank you, sir.
You're welcome. Good luck. Have a good weekend. All right, Ms. Plagani.
Good morning, Judge. I'm back on 252.
All right, and is Jim West here? Mr. West in the building. Jim West. Is that you with the hat on, Jim West?
Guess not.
That's one way to say no. Calling case number 2334-6252, Mid-First Bank versus Jim West and occupants on Strasburg.
And good morning, Judge. Solgal Plagany, P69690 for plaintiff. This is a summary process following a mortgage foreclosure sale. Redemption has expired. The property was served on April 24th of 2023 by the court officer, Carlton Carter. This is the second hearing. We're asking for a default judgment possession only with a writ to issue May 22nd of 2023.
Default judgment is granted.
Thank you, Judge. We'll get that faxed over. Have a good evening.
The judgment on that case.
All right, have a great weekend.
You too. Thanks, Judge.
And would you like to know?
Attorney Wyrock.
Good morning, Your Honor. I have 4 cases up at 10. Could we find out if any of the people are here so I could speak with them?
Absolutely. Is Megan Gardner here? And I'll do the same thing for you, counsel. So is Megan Gardner here? Is Janika Thomas here? Is Shane Kennedy here? Shanae Kennedy, excuse me. Shanae Kennedy.
Yes, I'm here.
How you doing, Ms. Kennedy?
All right, you.
Doing well. Are you represented by counsel? Do you have an attorney?
No.
Would you like to speak directly with the attorney's landlord? I mean, the landlord's attorney.
Sure.
Okay. I'm going to invite you into a breakout room with Attorney Rock. You see her at the top of the screen. She just spoke. If you all can work out a resolution, great. If not, let us know. Attorney Rock, if she requests counsel or your intuition tells you she needs counsel, feel free to send her over to legal aid. Good luck.
Thank you. And if you'll put me in the breakout room, I'd appreciate it.
Okay, room 7. I'll invite you to room 7. Okay, Sharice Greenwood. Sharice Greenwood. All right, is Diamond Berryman here? Diamond Berryman.
Yes, I'm here.
All right, did you have the opportunity to speak to an attorney or to plaintiff's attorney yet?
Yes, they actually I signed a
She signed a consent order for conditional dismissal, Your Honor. This is Neil Chanis, the attorney for the plaintiff.
Okay, all right, let's get parties' names and let's put this on the record. Calling case number 2334-4424. This is Seward New Center LLC versus Diamond Berryman and all occupants.
Good morning, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
Thank you. Good morning, counsel.
Good morning.
And Ms. Berryman, can you state your name for the record?
Diamond Berryman.
Thank you. All right, parties were at the last previous hearings, and it sounds like you all have a conditional dismissal that you agree on.
That is correct. That is correct, Your Honor. You want me to place the terms on the record?
Absolutely.
So there is currently rent in the amount of $4,660, court costs, including statutory attorney fees of $165. The total due is $4,825 to be paid on or before May 22nd, 2023. And Ms. Berryman has given me permission to sign her name to the consent order.
All right, and this is in the form of a conditional dismissal?
It is a consent order for conditional dismissal, correct?
Okay. So, Ms. Berryman, if these conditions are satisfied, this case will be dismissed.
Okay.
If not, though, on the other side of the coin, a judgment could enter and an application for eviction can enter at the same time. Okay. And we wouldn't come back to court. So that's what we're working with. You've given counsel consent for him to sign your name. Yes. We'll get the copy, we'll sign it and get it back out to you all. So good luck.
I will fax it over to the court today, Your Honor.
All right, thank you. You all have a great weekend.
Thank you.
Thank you. I have actually 3 others.
Yeah, we're not done. Yeah.
Well, but Treasurer Crocker is present in the courtroom, and we also have a consent order on that one as well.
Okay, and Ms. Berryman, you're free to leave.
Okay.
All right. Calling case number 2334-4426. This is Seward New Center LLC versus Treasurer Crocker.
For the record, Neil Chanis appearing on behalf of the plaintiff.
Thank you. And Treasurer Crocker, Ms. Crocker.
Yes, Your Honor. Good morning.
Can you state your name for the record?
Yes, my name is Treasurer Crocker.
All right, Ms. Crocker, you all were able to work out a resolution. Let's put the terms of that agreement on the record.
Okay, sure, Your Honor. This is a consent order for conditional dismissal. There is rent due in the amount of $5,165, court cost of $165 for a total due and owing $5,330. Under further conditions, it states that the defendant shall pay $1,000 every 2 weeks, beginning May 19th, 2023, and every other Friday thereafter until the amount in 2D and the current rent is paid in full. Ms. Crocker then gave me permission to sign her name to the consent order.
All right, is that your understanding of the agreement, Mr. Crocker?
Yes, Your Honor.
And is this a 4B conditional dismissal, counsel?
Yes, it is, Your Honor.
Okay, 4B means that, well, the conditional dismissal, if you follow these terms, this matter be dismissed. In the event these terms are breached, maybe a payment is missed, 4B on the conditional dismissal form and paperwork states that a judgment and a writ of eviction, an application for eviction can be filed at the same time. So just understand, if there's a breach, we don't come back to court. So just make sure you follow these terms. I'm comfortable with everything else. And you've given Mr. China's consent to sign your name, Ms. Crocker?
Yes, Your Honor.
Okay, all right, the court is satisfied. Good luck. Thank you, counsel.
Thank you.
I will fax that over to the court. Of the two that I have left, one of them can be dismissed, Your Honor.
Okay.
I believe that is.
Ms. Crocker, you're free to go. I think she
Thank
knows
you.
that. You're welcome. Okay, you have one dismissal and then one, let's see if they're here or maybe call a default.
Yep, Agina Jones, Seward versus Agina Jones. I believe that case number might end in 425.
425. Is that the dismissal?
Yes, that is a dismissal. She has moved out.
Okay, calling case number 233-44425, Seward New Center LLC versus Agina Jones and all occupants.
For the record, Neil Chanis appearing on behalf of the plaintiff. Move to dismiss without prejudice.
All right, granted. Dismissal without prejudice is granted. Counsel.
Thank you. And then I think we're hitting the 11 o'clock hour.
I think you timed it perfectly. So 425 is a dismissal.
Correct.
All right, and we entered that.
And then the last one is 427.
Okay. On case number 233-44427, Seward New Center LLC versus Jesse Riggins and all occupants.
Again, for the record, Neil Chanis appearing on behalf of the plaintiff.
All right, thank you. Is Jesse Riggins here? And is there anybody on Seward, 741 Seward? All right, time is now 11 o'clock. Matter was scheduled for 10 a.m. Defendant has failed to appear twice, really 3 times, but there was no service on the first one. So, counsel, what's your pleasure?
Your Honor, we are asking for a possession judgment only by default. We currently show rent and arrears in the amount of $4,845. Costs including statutory attorney fees of $165 for total possession judgment in the amount of $5,010 with a writ to issue after May 22nd if that amount remains unpaid.
Right. Defendant must pay $5,010 by May 22nd or a writ may issue. Surely can issue. Solely up to you, counsel. You have a great day.
Thank you, Your Honor. You too. Have a good weekend.
All right, thank you. All right, is Bernard Taylor here? Attorney Goethe, good morning. You have your break.
Good morning. Good morning.
And are you here for Chauncey New?
That's one of ours, yes. I'm here for plaintiff.
Ms. Lamonius checked in. I can do breakout as well. We're going to, let's clean up a few. We don't have too much left over on our morning docket. We've been moving along. There are a few impropers and a few people who I don't want to overlook, but.
I haven't seen.
Go ahead.
I haven't
No, go
seen a
ahead.
defense on my other two matters yet either.
Okay.
And
Is
they were-
Benjamin Shelley here? Corey McKinney?
Did you call me?
I'll call you next. I'm gonna call Attorney D. Butts, and then I'll call your case, Mr. Sire. I didn't call you. All right. So is Benjamin Shelley or Corey McKinney here? Calling case number 2334-6243. This is 532 Tidal Way LLC versus Benjamin Shelley, Corey McKinney, and all occupants.
Brian Gerda, P80756, appearing on behalf of plaintiff.
Thank you. Is anyone here? Let's see, 6243. What's the address on that property, council?
Address is 9000 East Jefferson Avenue, apartment 2512.
Okay, I have it right in front of me. All right, thank you. Is anybody in apartment 2512 on East Jefferson? No response. Tenant is failed to appear. The date of this, the time of scheduled hearing was 8:30. It is now 11:03. Council, what would you like to do?
A plaintiff moves for entry of a default judgment of possession only. There's $21,077.88 in rent, $160 in court costs for a total of $21,237.88 in arrears. No monetary judgment sought.
All right, defendant must pay $21,237.88 by May 22nd, 2023, or a writ may issue. Right, 1 second, file order. Call your next ones. Attorney Zahar, you're on deck.
Yes, Your Honor.
You're on. This is 6243. Is LaShawn Jean here? Is Annette Jean or Karita Tickle?
Are you trying to say Annette Green? Annette LaShawn Green?
Yep, Annette LaShawn Green. And who said that?
This is Karita Tickle. Annette is my co-signer.
All right, Ms. Tickle, and where are, can you say something again?
Right here.
Okay. All right, thank you. Attorney Gerda is here from, are you about to go to graduation or something? Are you? Okay. Oh, no, that's your work, Jack. All right.
For me?
No, I thought you were, no, never mind. Do you have an attorney? Are you represented by counsel?
No, I couldn't find a lawyer.
Okay. In the event she requests counsel, please send her to invite her to a breakout room. I'm gonna invite you to a breakout room with Mr. Gerda. There's counsel available, but Mr. Gerda is here as well, and you all might as well have a conversation. If you need.
I did speak to a lawyer and they was telling me everything, but I wasn't able to get the pictures developed to bring them to you.
Okay, well, let's talk, you all talk, and if you come up with a resolution that works, it works. If not, then we can hold it here.
Okay.
All right, I'll join room 3.
All right, good luck. And Attorney Zaire. Calling case number 2-334-4518. This is Sarah Fayyad versus Clarence McCord and all occupants.
Hi, Your Honor.
How you doing? Is this
Sabree McCord.
Okay, hold on, let me see. I don't have 518. You said Clarence McCord?
Yes.
Okay, I'm sorry, it's on here as Clarence. I can see how they probably got that. Okay, and you live at 220 Lake Point?
Yes. Hold on.
Okay. And Attorney Zaire. Do you have an attorney, Ms. McCord?
No, because I gave the landlord the keys and moved out. So. Ow.
So there's not much to talk about.
No.
All right, looks like we'll call your case as soon as the attorney's back. He may have stepped away from his seat for a brief second. So.
Okay.
Yeah, so as soon as Attorney Zaire's back, we'll call that case. And yeah, so just sit tight.
Okay.
All right. Calling, all right, parties are here.
Yes, Your Honor.
Miss McCord.
I'm here.
Can you state your name for?
Sabree McCord.
And counsel?
Your Honor, Mohammed Zahir, P number 5, 2020, appearing for the plaintiff.
Thank you. The defendant has notified the court that she's vacated the property at 11220 Lake Point. And can you confirm that?
Oh, I do not know, Judge. I do not know if that's true. But if she stated that, if she allowed my client to go to the property today, based on her representation, then we can enter a dismissal.
Yeah,
Okay.
your client is at the house now with the keys.
With the key? Okay.
He has the key. He's there right now.
So my client can go to the property with no issue.
Yes. The new owner that he sold it to is there. He has the keys. He's there.
Okay, but as far as you is no longer in the property,
No. Nope.
nor any all occupants in the property.
No, we're all done.
Well, Judge, based on her representation, if that's true, I will move to dismiss.
Okay. Dismissal without prejudice is granted. It looks like parties were here at the last 2 hearings, so thanks for showing up. And you all have a great weekend.
Thank you.
Thank you so much.
Well, our hands full.
Yeah.
Well, And Attorney Brown, I saw you pop up.
Yes, Your Honor. I just spoke with Mr. Brantley. His Zoom profile says TW102. He's on the case with Alicia Woods. That's an in pro per landlord. It's a motion to stay proceedings.
Okay, that's the motion to stay. Thank you, thank you. All right, and we're gonna take a brief, quick break. I'm gonna give my court reporter a 5-minute break. And we'll be back up with Tony Bragg. Tony Bragg, you're next.
Yes, I'm here.
And then we'll call, are you representing him, Mr. Brown?
I'm not representing him. I did want to just kind of fill the court in a little bit on what I discussed with him, but.
Okay, when I call it, will you be around?
I'll be around.
Okay, all right. So let's take a 5-minute break and we'll be right back.
Thank you.
You're welcome.
Is there Philip Dawson here?
Hello, hi.
Yes, sir. Is there Bradley Dawson?
I'm right here.
Okay, you have something to the report?
No, I'm on the phone. Yes, you're signing in. Oh, I'm signed in, yes.
Sir, you signed into the wrong courtroom.
You're in the wrong courtroom? I'm in the wrong, I'm sorry. Can I get the number for the right courtroom?
Yes, do you have a pen and paper available?
Yes, I do. I'm ready.
Okay, write down this Zoom number.
Uh-huh.
It's 360
Uh-huh.
538
Okay.
0000.
So 360-538, 4 zeros.
That's to Sean Jacquet.
Thank you so much. So how do I sign out of this and go to that room?
We can get you out of here.
Thank you.
Yep. All right, TCL 9137W. Good morning. With the hat and the hoodie. Blue hoodie. The hat. Put the hand up. All right, Attorney White Rock.
Yes, we are ready with 533. We have a hearing judgment.
All right, calling case number 23346533360 Vision RE Inc. versus Shanae Kennedy.
Diane Wyrock
Yes.
Diane Wyrock on behalf of plaintiff P59773.
Good morning, Attorney Wyrock.
Miss Kennedy, could you state your name?
Yes, Shanae Kennedy.
All right, Ms. Kennedy, thank you. And you reside on Sussex?
Yes, sir.
All right, Attorney
Your
Wyrock.
We have agreed on a hearing judgment. We're going to convert it to a non-payment case. We are going to dismiss Miss Kennedy from the case, and it'll be a judgment only against all occupants. The total owing is $6,330 plus $160 in court costs for a total of $6,490. Miss Kennedy is going to pay $3,000 on or before May 31st. And then thereafter, she will pay her monthly rent, which is due on the 1st, together with an additional $400 until the arrearage is paid in full. Failure to make a payment, writ to issue. And she is also going to transfer the water bill into her name. Is that correct, Miss Kennedy?
Yes, ma'am.
All right. Let's repeat this. Okay. So court is going to enter a judgment by hearing and convert this from a termination of tenancy case to a non-payment of rent, which means you can redeem now. You can redeem your party. Furthermore, the named party, Ms. Shanae Kennedy, will be dismissed. And this judgment will be in all occupants, where all occupants are obligated to pay $3,000 by May 31st, and then your monthly rent as scheduled, which is how much?
$800.
Okay, which is $800 plus another $400. And you'll continue on with this until your rental arrearage is paid in full. So you'll also all occupants, you, Ms. Kennedy, agreed to transfer the water bill in your name.
Yes, Your Honor.
All right. Okay, this is a judgment by hearing, so technically 4.201 wouldn't apply, Attorney Wyrock. So let's enter the judgment by hearing so we can put all occupants on there. Do you have any questions, Ms. Kennedy?
No, that's all for today. And how long will it take me to get a judgment?
I will prepare it today and fax it in, so you should get it within the next week.
Okay, perfect. No problem.
Are you awaiting assistance, Ms. Kennedy?
No, but I'm going to pay cash for what I have to pay by the end of the month, and then I'm going to try to get some for the other amounts. I get the paperwork.
Okay, so you should get in. You should get in fairly timely fashion. But you know, 3K by the end of the month, and then 800 plus 400 until the rental overage. But we'll get you something. All right. Good luck, and you have a great weekend.
All right, thanks. Thank you.
Thank you, Ms. Kennedy.
You're welcome. Thank you.
Your
Bye.
Honor, could I do the other 3 cases that I have?
Sure. Is Megan Gardner here? Calling case number 2334-6529, Littlefield, Detroit versus Megan Gardner and all occupants.
Diane Wyrock on behalf of plaintiff P59773. This is a termination action for 9539 Beechwood in Detroit.
All right, Megan Gardner. No one has responded. Parties failed to appear at the last hearing. Defendant failed to appear at the last hearing. I won't put you in that same boat. Counsel, are you requesting a default judgment?
I am, and 10-day move out.
Termination. This is the termination of tenancy case. Defendants must vacate by May 22nd, 2023, or writ may issue. That is 529.
Thank you.
Calling case number 2334-6531. This is 11296 Minden LLC versus Janika Thomas and all occupants.
Diane Wyrock on behalf of plaintiff P59773. This is a termination action for 11296 Minden in Detroit.
All right, does anyone live on Minden Street? And if you do, please press *6 if you're on the phone. All right, counsel.
I request a default judgment.
All right, this is the termination of tenancy case. Ms. Thomas failed to appear at the hearing. Default judgment is granted. Defendants must vacate by May 22nd, 2023, or writ of eviction may issue thereafter.
Thank you.
Well, calling case number 2334-6534. This is IC Real Estate Inc. versus Sharice Greenwood.
Diane Wyrock on behalf of plaintiff P59773. This is a termination action for 15702 Ferguson in Detroit.
All right, does anyone live at that address? And there was no response at the previous hearing, Attorney Wyrock. Attorney Wyrock, would you like
A default judgment, please.
Default judgment is granted. There's no one to contest your request. This is a termination of tenancy matter. Defendants must vacate by May 22nd, 2023, or writ can issue.
Thank you very much, Your Honor. Have a wonderful weekend.
All right, you too. As promised, calling case number 2334-6261. This is Tony Bragg versus Bill Bragg and Tierra Roby.
Yes, Your Honor. Yes, Your Honor.
And good morning. Can you state your name for the record?
Tony Bragg.
Thank you, Mr. Bragg. And
Thank you, sir.
You're welcome. Is Tierra Roby here? And Mr. Bragg, did you have someone serve this document?
I went to the court and they said they was going to mail it out. I believe that's what they told me. This was back in February. No, March. Yes.
Okay. Did you get a copy of the proof of service?
Excuse me?
Can you check? I'm gonna check the computer to see if there's proof of service. Sometimes we don't get all these documents timely. Just want to check one thing.
Thank you. Okay.
Wow, fast. Service. It's not showing that Ms. Roby was notified for the hearing. There's no proof of service in the file. And I don't have it in the computer.
I thought when I came down to 36, I paid for them to serve that. I'm quite sure I don't have my receipts. I don't have my paperwork in front of me, Your Honor.
Yeah, I don't have a proof of service in the file. Is it possible to be able to can you track it down? We still have a bit of a hearing. We still have a few cases left. I can recall it.
So you saying, can I come down, you saying?
No, can you find the proof of?
Okay. All right. Give me, so just I'll chime back in. How long you got? About a half an hour? Let me run to the house.
Yeah, we have about, I would say, we for sure have a half an hour.
Okay.
Okay, all right.
All right, thank you.
You're welcome. And let's see. Is Janae Gotti here? Gady? Alicia Woods? Alika Woods? Versus Shayla Burt?
Yes, I'm here.
Okay, is it Alicia or Alika?
Alika.
Okay, all right. All right, Miss, is Shayla Burt here?
No, but Devontae Brantley is. I'm under all occupants.
Gotcha. All right, calling case number 2239-6130. Alika Woods versus Shayla Burt and all occupants. Could I have appearances starting with you, Ms. Woods?
Alika Woods, I'm the plaintiff.
Connor Brown, P79949, on behalf of the defendant on an advice-only basis.
All right, thank you, Mr. Brown. And can you state your name for the record? TW 102. Yes.
Oh, my name is Devontae Brantley.
Devontae Bradley.
Brantley, yeah.
Okay. All right, we're here today for emergency motion to stay proceedings. This matter was originally filed December 1st, 2022, last year, roughly 6 months ago. It was a non-payment of rent. This matter was adjourned from December 22nd to March 7th. March 7th. And in the meantime, summons and complaint was sent. The case was moved up from March 7th to March 27th. It was switched to my courtroom. Parties entered into a consent judgment. Then there was an order to set aside the judgment that was entered. Then the judgment to consent, a consent judgment was, okay. Then an order of eviction was filed in April 10th. Order of eviction was entered. And on April 24th, a motion was paid. A motion was paid and a motion was filed, which was granted. Well, and today we are here for a motion to stay proceedings, to stay in eviction. So this is your motion. Was it Mr. Brantley?
Yes.
All right. Why should this eviction be stayed?
Because I tried to pay her the money that was owed in the judgment.
Okay. Now, was it accepted?
No.
All right. Was it the full amount?
I sent $2,400. The full amount I think was $2,977, and I was getting the money order for the other $400 or $500. I sent the money through Cash App, so I got a receipt.
Oh, so the money was sent.
Yes, but I sent $2,400, and I needed to get another $500 in a money order, but she refunded me the money the next day, and she said she did not want to accept the money. So this is where we is.
Okay, this is where we're at. Okay. Ms. Woods.
That is incorrect. He paid $2,370 through the Cash App on April 22nd, which was after the eviction was filed, and it was short. The total balance to retain the property was $2,997.39 payable by March 31st, 2023.
All right. So we're here today. Do you want the payment? Or do you want an eviction? Ms. Woods, are you willing to accept payment in full for the judgment, to satisfy the judgment amount?
I would like to move forward with the eviction because he's outside of the time frame and the money was short. My paperwork specified that partial payment will not stop the eviction proceedings. And I even spoke with him as a courtesy prior to filing my eviction to notify him that I was filing the eviction. Was it possible that he can move before the filing because I'm charged whether there's a stay? He did not move. He did not pay because he didn't have the total. And I moved forward with my eviction. And the person who came out to execute charged me for a balance for not moving forward, I guess for his time for coming out. So my opinion is he failed to meet the criteria for to maintain the premises. So I would like my eviction, please.
That's not true though.
Your Honor.
How is it not? But
I just wanted to say, I think that there's case law that says, even if there's a deadline in a judgment, as long as payment is tendered, I believe it's before an eviction order is entered, that's sufficient. And it sounds like Mr. Brantley attempted to do that. He made the Cash App payment for the vast majority of it, and told the plaintiff that he had a money order ready to go for the rest of it, but she declined and sent the money back. It seems to me that
There's an escrow.
That's incorrect.
All right, when was the money sent to you, Ms. Woods?
4/22/23, after the eviction was filed. And he stated that he needed until the following week to come up with the balance. Will I accept it?
No, that's not what I said. I said
That's
I had
exactly
a
what
money
you
order.
said. And then you tried to make arrangements for March and April.
Right, but that was before we even got to May though, Ms. Wood.
All right, so what about this? What's the deal with the money in escrow?
I mean, I have the copy of the Cash App. So we don't have to debate the balance.
Cash App. How much? There's $900 in escrow. Where'd that come from?
I put that in there.
You put that in there?
I tried to put all of the money in there that I owe. They said that they will not hold the money for me at the court. I tried to put the $3,000 in there. They said they wouldn't hold it. So he said, how much is your first month's rent? And I put the $900 in there. I don't really know what's gonna happen. I think the relationship is completely deteriorated and money won't even fix the situation.
I think
that's
you're
how
right.
I really think. So all I'm asking for is
no, go ahead. What are you asking for?
All I'm asking for is maybe a little more time to just be gone. I tried to pay the money. I don't really know what else to do. I'm sure she going through it and I'm going through it as well.
Well, no, when we had our conversation before I made an appointment for the eviction, I asked, how much time did you need to move?
How much time are you willing to give?
He did not respond.
It doesn't even matter. Are you willing to give, I forgot your last name, sir.
Bradley.
Mr. Bradley, are you willing to give Mr. Bradley any time to vacate? That's a question for you, Ms. Woods. Are you willing to give Mr. Bradley any time to vacate?
No, I feel he's had sufficient time already.
All right, I'm going to order the release of the escrow back to the defendant in the amount of $900. Were you refunded the rest of your money, Mr. Bradley?
Yes.
All right, keep your money because the landlord is not willing, Ms. Woods is not willing to accept it. I cannot extend your time, and I'm going to deny the emergency motion to stay the eviction, and parties may proceed. Seems like this landlord-tenant relationship has indeed deteriorated.
Okay, but what I'm saying is I need at least 5 days to get all my stuff out the house. She don't want to give me no more time. I need at least a week.
This is the thing, the eviction is already signed. So I can't stay the eviction. I'll stay the eviction until Monday. But you have to, if I stay the eviction until Monday, what's 900 divided by 30 times 3?
900 divided 30 times 3. Hold on, let me see the count.
Is your monthly rent $900? Was it $900?
It was 800.
All right, let's do 800. 800 divided by 30.
Excuse me, Your Honor. His rent includes water and gas.
800.
I never paid water and gas though, Ms. Woods.
$800 divided by. What is the monthly rent?
I thought it was 800. I have not ever paid water or gas since I've been staying in the house. I've been there 2.5 years.
Because I've been paying it.
Ms. Woods, what's the monthly amount? If it's not 800.
No, what I'm saying is the monthly amount is 800 per month, which includes water and gas.
Okay.
Come up with
So
800
divided by 30 is 26 times 3 is $80. So I'm going to award $80 to the landlord, and out of this $900, $810 is to be awarded back to the defendant, and going to stay this writ of eviction until Monday.
Okay, how long would I have to be out?
Monday, May 15th, a writ can be executed.
Okay.
And
I don't even
$80,
know.
I took $800, I divided it into 30 days. Because you'll be there for 3 additional days, you have to pay her for those 3 additional days, which is $80. So she'll receive $80 from the escrow, and you'll receive the other $810 from the escrow
Okay,
release.
what 3 days you said I'm gonna be there? Friday, Saturday, and Sunday?
Yeah, Friday, Saturday, and Sunday. A writ can be executed on Monday.
Okay.
All right, parties. Good luck, Mr. Bradley.
All righty.
All right. Okay, so an escrow order will be sent out or entered into the computer where 810 will be released. I'm sorry, my math is wrong. 820 will be released to you, Mr. Bradley. And what was the cost? Excuse me, what was the cost of, are you gone? Is Ms. Woods gone?
No, I'm here.
All right, what was the cost of the bailiff?
$150.
All right, well, we're gonna do 150 plus. We'll do 75 plus 80. It's 155. Okay. So I'll put an escrow order. I'll do the whole 150. I'll do the whole 150 plus 80. I don't know why I did half. So 230 is to be awarded to the plaintiff, Ms. Woods, and the remainder goes back to Mr. Bradley. And Mr. Bradley, what's your full name?
Devontae Brantley.
D-E-V-O-N-T-E?
Well, D-I-V-A-N-T-E.
Okay. Devontae Bradley. All right, we'll prepare an escrow release, and that concludes this matter. Mr. Bradley, you probably have until Monday to vacate until, because the writ is already out there, and it should be executed on Monday, May 15th.
Okay.
All right, good luck. Have a productive weekend.
All righty.
All right, take care. All right, Ms. Woods, you're free to vacate. You are free to leave. All right, counsel. Mr. Gerda, do you have any, is Mr. Mayers here? All right, Mr. Monius is here. Party's ready on 532, or do you, is LaShawn, go ahead, counsel.
We're ready on this Tiggle, the Karita Tiggle that's ending in 404.
All right, let's call that first. I know this will probably consume the rest of our morning docket, which is not a problem, but I'd rather not have anybody else waiting. So, who else is here? Attorney, Mr. Bragg is here.
I have another one with Miss Lemonius.
No, that's the one I'll call second. So calling case number 233-44404, Santa Fe Fellowship LLC versus Annette Jean and Ms. Karita Tickle.
Good morning again, Your Honor. Brian Gerda, P80756 on behalf of the plaintiff.
Good morning. Annette Green here.
Oh, she's my co-signer.
Oh, that's right, Mr. Tickle. Good morning. Can you state your name for the record?
Karita Tickle.
Thank you, Ms. Tickle. Parties, would you like to put was the resolution worked out?
Yes, Your Honor. We had an opportunity to speak in a breakout room. We're going to present to court for signature a conditional dismissal. This is a termination of tenancy case, so no rent will be addressed. The case will be conditionally dismissed with a vacate date of June 9, 2023. 4B will be checked.
All right. 4B means that a judgment and an application for eviction can be entered at the same time in the event that the conditions aren't met. On the condition that you move out June 9th, 2023, case is dismissed. If not, a judgment and a writ will issue any day after June 9th upon the plaintiff's actions. A judgment and a writ of eviction can be filed. So do you understand that, Ms. Tickle?
Yes.
All right. Do you have any questions?
Yes. Well, by them not wanting the rent, do they keep the security deposit?
Mr. Gerda?
So this has nothing to do with the security deposit. That has its own separate procedure that's followed after you vacate the property.
Okay.
I think it has something, it's a separate procedure, and it would be based on the move out proceedings and how it goes if there's any issues. So this would be conditioned upon, this case would be dismissed, conditioned upon a move out. That seems like the only condition that exists, and just make sure you notify the landlord and stay in touch or provide them with a forwarding address for your security deposit. That's important.
Okay.
All right. Well, that concludes this matter. Good luck, Ms. Tickle. And we'll have a great day. Well, Attorney Gertie, you're still here. But you are free to leave, Ms. Tickle.
Okay.
All right, is Attorney Mayers here or Blackstone Cooperative? Calling case number 2239-3532. This is Woodbridge Senior Village versus Chauncey Newton.
Good morning again, Your Honor. Brian Gerda, P80756 on behalf of the plaintiff.
Good morning, Your Honor. Lauren Lamonius, P83053 on behalf of the defendant in this matter.
And this matter was originally scheduled to be heard. Okay, I'm sorry. Is Chauncey Newton here?
He is not present at this time, Your Honor.
Okay.
And Your Honor, my client, Louise Dorsey, said she was waiting to be let into the courtroom. Do we have anybody in the waiting room?
I don't have anyone in the breakout room. I mean, in the waiting room. Would you like me to recall it? Would you like to get in touch with her and call it?
Trying to figure out if she might be in a different courtroom. Maybe it won't be necessary.
Thank you.
Okay, well, today's the date and time. I think the last hearing we had a bomb threat, and we had to canceled the hearing, then we had to reschedule it, so parties were afforded a bit of time in between the previous hearing and today. So today, this is defendant's motion and brief for summary. This is defendant's motion for summary disposition. So I'll let you lead the way, Ms. Lamonius, and I have plaintiff's response to the motion for summary disposition. So we'll hear both arguments, starting with you, Ms. Lamonius.
Yes, Your Honor. Before I get to the my arguments in the summary disposition, where I am asking you to dismiss the case because the notice to quit that the defendant was served was improper. At the last hearing, Attorney Jen Weirborn appeared on behalf of Attorney Cox in this matter, and I did indicate that I needed some additional information, that I had sent out a discovery request to Mr. Cox's office, requesting a number of documents, including some inspection reports from tenants' property, as well as information regarding their knowledge of the defendant's disabilities. And you did indicate that you would like to see those documents as well. You did order the plaintiffs to provide those documents to you and to myself and to the court via the email. At this time, I still have not been in receipt of those documents. So a number of the documents that I requested in discovery have not been received by me at this time. I would ask that this case be dismissed because the notice to quit that the defendant initially received was defective. The defendant was required to have the notice mailed to him and have the notice given to him in person. And if that in-person notice was unavailable, to have it affixed to his door. That did not happen. Further, the complaint, the notice only alleges that defendant was participating in some harassing activities. I did want more information about what those harassing activities would be, and I do not believe that we've received even enough information about what Mr. Newton is allegedly accused of. So I would ask that this case be dismissed at this time.
Counsel, would you like to respond?
Yes, Your Honor. So number one, my notes here show that all documents that we have were given on May 3rd. So that didn't happen. I guess is the argument. No, can't confirm that. All right. The documents were given on May 3rd. So that's false, what we're hearing right here. With respect to the motion for summary disposition, they haven't pointed out to anything that's deficient with the notice to quit. This is a violent individual. Police report, the incident reports.
I object to the.
I'm sorry, can I speak without being interrupted?
Go ahead.
The police reports were provided in discovery. I see that here in the file as well. On the violent behaviors, the notice to quit gave all the information. So the argument for dismissal is severely lacking any legal basis or merit.
What authority? I see a notice to quit to recover possession of property. What's the issue with the notice to quit?
Your Honor, defendant is in federally subsidized housing and it is governed by 24 CFR 2B, and it requires that in order for service on defendant to be properly effectuated, defendant must be first served via first class mail and by serving a copy of the notice on any adult person answering the door at the least dwelling unit or by placing the notice through the door of the dwelling. He was served by mail only. The notice to quit is only checked by first class mail.
Okay, how do we know he was only served by mail?
That's what the notice says, and the defendant did indicate that nothing was ever posted on his door or slid through his door.
You have a statement of that?
I not. I have defendants told me that, and when I look at the notice, it does not indicate that it was posted on the door. It only indicates that it was mailed, and that is improper under 24 CFR section 247B2. Furthermore, Your Honor, to the extent that
247B2 or 247 dots.
24 CFR section 247B2.
D2.
B, like as in boy.
No, we'll help to have him here testify. You're not receiving it, but all right, let's see. 247 B2.
Yes.
See what this says. Okay, cool. Ms. Lamonius, can you read the language from 247 B2?
1 second, Your Honor. I do not have the statute pulled up in front of me. I simply have it, the language in my brief, but it does require that service be sent first class mail and upon a person at the door. But give me a second and I could pull up the statute.
Your Honor, just so I can keep up here, what are we looking at? I just heard reference to a statute, but I thought we were looking at federal regulations.
Federal is well, it's not a statute, it's an act. It's
Right.
20
It's a federal regulation. I don't even know why that's being discussed. That's between my client and the agency. It provides no sword or shield here. It's a federal regulation. It's not law. But I heard statute, so I want to make sure I'm looking at the same thing everybody else is looking at.
You didn't the statute part. It's 24 CFR 247B, 247.4B. Manner of service, the notice provided in paragraph A. All right, it says the landlord's determination to terminate the tenancy shall be in writing and shall state the tenancy is terminated on the date. State the reasons for the landlord's actions with enough specificity as to enable the tenant to prepare a defense, and advise tenant if he or she remains in the lease unit on the date specified for termination that the landlord may seek to enforce the termination by bringing a judicial action at which time the tenant may present a defense and be served on the tenant in the manner prescribed in paragraph B. That's checked. The notice provided in paragraph A of this section shall be accomplished by 1, sending a letter by first class mail properly stamped and addressed to the tenant at his or her address at the project. Was that accomplished? Yes.
Yes, Your Honor.
Okay. And 2, serving a copy of the notice on any adult person answering the door at the least dwelling unit. Or if no adult responds, by placing the notice under or through the door if possible, or else by affixing the notice to the door. Was that accomplished?
No, Your Honor, that was never accomplished.
And how are you certain?
The notice only states that it was mailed. On the notice, it does not indicate that it was also personally served or that it was posted on the door after failure to answer the door.
Okay, is that actually the case?
Yes, Your Honor.
All right. How are you able to confirm that happened?
I've spoken with my client, I've looked at the notice and the client is currently having some health issues, which is why he is not here. But I could, if you would like to have him state that on record, indicate that as well.
Counsel?
Yeah, me, Your Honor?
Yes. Yes, sir.
Yes, again, these regulations are not applicable in this case. There's a reason there are regulations and not statutes. These are not law. This is between my client and the agency that provides the subsidies to them. It's there. That's what it's regulating. It does not create a private cause of action here whatsoever as a form of a sword or a shield. The bottom line is the defendant is well on notice of his behavior at the premises, is well on notice of his proceedings, and they're trying to find anything they can to avoid the fact that my client terminated the lease, as they're entitled to do when there's a clear material breach of the underlying terms. If the court would like, my client is also available to provide testimony if we want to go into how that service was made. Maybe there was a knock on the door. I don't know those details because, frankly, again, Your Honor, it does not matter in my legal analysis what a CFR says, not for purposes of summary proceedings.
Your Honor, in my legal analysis, in order for the court to have jurisdiction over this matter, proper subject matter over this matter, proper subject matter jurisdiction over this matter, the defendant would have needed to be served correctly because the defendant is a tenant in this federally subsidized housing.
So if I don't have jurisdiction over this matter, who does? Over the jurisdiction. I don't know the answer to this right now. I don't know if an act precludes this. I know that this argument is very narrow, and if this case was dismissed, the party could just refile it and cure it. But who I would like to bring, I don't know, you're testifying for your client, Mr. Moniz.
Yes, Your Honor. I would also like to state on the record that the notice did not provide any information beyond that the defendant participated in some alleging harassing activities. Attorney Gerda did state that on May 3rd, the Cox firm provided those requested documents to, I'm not sure if they were provided to the court. They have not been provided to me. On record, you did indicate that you wanted them to be emailed to you. You wanted us to stay in the loop. I have not heard anything via email. I have not received any mail stating that those documents that you were requesting had been submitted by plaintiff's counsel. I have not seen them, and to my knowledge, they have not been received.
And this is the summary proceedings action. So let's take that in consideration. So, I mean, the information exists, parties have it, send it over. If it doesn't exist, I'm not really stuck on that issue. I think both parties need their defendants here, the plaintiff and the defendant, to testify. Bring your clients so they can testify, so then we can get some fact finding going on. Then
My
I'll-
client's ready, Your Honor. I think she's still in the waiting room.
And I could produce my client within a few minutes.
All right, let's do it. Let's do it after lunch. Let's do it at 1. Let's do it at 2 o'clock. Let's recall this case at 2 o'clock, and then we'll hear it. There'll be no more cases on the docket. We'll have all the time in our review, whether federal regulations can prevent eviction. My jurisdiction on regular federal regulated houses. See you all back at 2 o'clock.
All right, see you then. Thank you, Your Honor.
Well, is Blackstone Co-op present? Or is Johnny Marsh here? All right, TCL with the hat on and the hoodie. I've been trying to figure out who you were for a while now.
Okay, my case number is 233-46548.
Timothy Edwards. Ordinary Porter.
4548. And what's your name, sir?
Larry Porter.
All right, is Timothy Edwards or Natasha Edwards here? Calling case number 2334-6548. This is Larry Porter versus Timothy Edwards and Natasha Edwards. Can you state your name for the record?
Porter.
All right. And Mr. Porter, do you own the property at 15988 Chalfont?
Yes.
All right. And did you serve the defendants at that address?
Yes.
All right. Do you remember who served your documentation?
Lee Gordon. I sent the copy with the thing to you. The receipt, the receipt notice.
Okay. And Lee Gordon?
Yep.
And we have confirmed in the computer. All right. Is Timothy or Natasha Edwards here? Are they still currently residing in the property? Is anyone in that property, Mr. Porter?
Yes. Last time it was someday was there.
All right. Are you requesting a default judgment?
No.
All right. Defendants fail to appear, default judgment is granted. Parties must vacate by May 22nd or a writ of eviction may issue. Please submit a judgment to the court and we'll sign it.
Say it again.
Please submit a judgment to the court and we'll sign it. Default judgment is granted. Defendants must vacate by the 22nd of May. But we need a judgment. We need a judgment. We don't get a judgment, that 10-day period is just gonna move along because I can't.
How do I get a judgment?
Second floor. At the court. Either the second floor of the courthouse or print one up, print a PDF version up and fill it out, and then you can fax that in. But either way.
Oh, go to the floor. Okay. Okay.
All right, take care. Good luck. Calling case number 2334 CR436 this is Blackstone Cooperative versus Donna Bowler or Donna Holiness. Let's see. 378. The name is Donna Holiness Bowler. This is Blackstone with Ralph Mayers. The address on South Norfolk. All right, parties failed to appear. Dismissal without prejudice is granted. Parties may refile whenever or file a motion. On case number 23345-149, Bill Properties versus Roman Ledbetter. Occupants are Hartwell. On case number, there's Roman Ledbetter here. All right, this was Bill Properties versus Roman Ledbetter. Neither party appeared. It's going to enter dismissal without prejudice. Hopefully parties resolve this. Just got to appear at court. Bernard Taylor. Bernard Taylor, calling case number 2334-6542. Bernard Taylor versus Rosalind Pearson. Nobody's here, dismissed without prejudice. Parties failed to appear. On case number 23345-144, this is 855manager.com versus Johnny Marsh. This is Attorney Piper's case. This was adjourned to May 12th. So I'll hold off on dismissing this case. I saw the parties here.
Judge, I think we did a consent judgment on that one.
Okay.
And moved by June 3rd.
That was a consent judgment. All right. Perfect. All right, this case was already called. Thank you.
You're welcome.
Thank you, Mr. Nevels. Mr. Bragg. Mr. Bragg. Can you hit star, was it star 6? I'm gonna set your case over to the afternoon, Mr. Bragg. If anyone talks to Mr. Bragg. All right, what cases are you all here for who are just coming in? Donna Cheatham?
Good morning, Your Honor. This is Bernard Taylor.
Good morning. What case are you on? Okay.
This is Bernard Taylor versus Rodland Pearson. It's 233-46542.
All right, and is Rosalind Pearson here? Is Miss Pearson here? Recalling case 233-46542. This is Bernard Taylor versus Rosalind Pearson. Bernard Taylor, can you state your name for the record?
Yes, Bernard Taylor.
All right, this matter was previously dismissed without prejudice. Court will set aside the dismissal without prejudice because Mr. Taylor has appeared in court. Mr. Taylor, do you own the property at 16810 Archdale?
Yes, I do.
All right, is there someone that's still occupying that property?
Yes, she is.
All right, Mr. Taylor, are you requesting a default judgment?
Yes, I am.
All right. This is a complaint to recover possession of property. There's no amount to redeem this property. This is solely a possession judgment. Defendants, this is Rosalind Pearson and all occupants must vacate by May 22nd, 2023, or a writ may issue. Please submit a judgment to the court. We will sign it and get it back to parties.
Okay, thank you, Your Honor.
Default judgment is granted. You are welcome. Take care, Mr. Taylor.
Thank you.
Donna Cheatham.
Yes.
How you doing? What case are you on?
I'm on. Let me see. Say something about where I live at. A land contract. She claimed I owe $447 from where I don't know.
Do you have a case number, ma'am?
Yes, it's on the top of my paper. The case number is 346362.
Two, 346.
No, you say two. No, it's just.
And does it have a judge that's listed?
Can you hear me?
Yeah, I can hear you.
Oh, okay, I didn't hear you.
Yeah. We're looking up your name.
Oh, okay, because I have a paper here that say Judge Adam Sabree.
That's me.
Okay.
How do you spell your first name?
D-O-N-N-A.
See anything, Judge. And you don't have a case, and no case number. Does it say?
It say 346362.
346362. It should be 8 digits.
What about 2023? No. 346, 362, that's on this paper.
Is that on the top right-hand corner?
Yes. That's all it got on here. 346, 362.
And what's the date to appear?
Today. At
May
one.
12th?
Yeah.
Oh, at one. Oh, yeah, well, that helps. Okay, well, if you're on a 1:30 docket, you're early. Would you like to speak to, okay, I see you down in Cheatham.
Thank you.
All right, do you want to speak to, legal counsel?
Yes. I guess if that's the best thing to do, because I got all my receipts and everything right here in front of me.
I believe you, Mr. Cheatham.
Yep, Ms. Cheatham, you'll get a prompt in a second, and then we'll have an attorney from Lakeshore Legal Aid speak with you.
All right, thanks, Mr. Keenan. All right, we're gonna call it early. There is a Tony Bragg that is looking for his proof of service. He may pop back in, but let him know I didn't default him in this case of being an afternoon. If you're here, let's see. Anything else? We'll be back at 1:30. So.
All right, we'll try to get Ms. Cheatham started and then see you in an hour.
All right, sounds great. Okay, all right, folks, we'll be back.
All right, Judge.
Hey, Donna.
Hi.
You can just, yeah, you can turn, if you can turn off your camera, no one's here, but you don't have to wait until, no one's gonna be back till 1:30.
Yeah, the phone had fell, cut off, and I was disrupted.
Yeah, I was able to get you back out of the waiting room. But yeah, it'll be about 15 more minutes and then we'll be rolling.
Okay, so what should I push on my phone?
I mean, you can just flip it over. I can mute your device for you.
Okay.
All right, I have you muted. Yeah.
Morning.
Good afternoon. How are you?
Hi, good afternoon.
The judge will be with you shortly.
Can I get a breakout room with Miss Cheatham?
I don't have the capabilities to give them to you right now.
Ms. Davis, I have them. I can name it.
Oh,
Mr. Rubberman.
thank you, Mr. Keenan. Okay, yeah.
Yeah, I met with Ms. Cheatham earlier. I gave her some advice. We're not representing her at this time, but I
Okay.
will definitely let y'all sort this out. But I'll be here if you need me.
Okay, so you can give them breakout rooms?
Yeah, I can put them in a breakout room. I can't give the
Okay,
total
cool.
privileges till the judge gets back, but I'll send
Okay.
y'all the room for.
Okay.
Sir?
Ms. Cheatham, you'll see a prompt on your
Do
screen.
you want to be part of this so that she doesn't think I'm pulling a fast one?
Sure.
Okay.
I'll see you there.
I'm ready to know. Uh-huh.
Good afternoon, everybody.
Good afternoon.
Good afternoon.
All
Good
right, this is
afternoon, Judge.
good afternoon. Happy Friday.
Yes.
Happy Mother's Day and for the pies.
Thank you, thank you.
Thank you.
Thank you, thank you.
All right. Are there any people who have resolutions? Are there any dismissals? If you have any dismissals or have any resolutions, please put your hand up in the chat or chime in and I'll call your case. I don't want anybody sitting if they don't have to.
Marilyn Williams.
Marilyn Williams, is your matter supposed to be dismissed?
Yes, sir.
Your Honor, this is Tony DeGard from Lakeshore Legal Aid. I represent Ms. Williams. We do have a conditional dismissal ready to put on the record, but let's wait for opposing counsel.
Okay, yeah, we can wait.
This is a case that was adjourned from last Friday, so it might not be on your desk right now, but yeah, we just got a 1-week adjournment to work this out, and we did, but I'd wait for the opposing counsel.
All right.
Okay.
Is that do you have a digital background or is that real art?
That's real art. I got it at an estate sale.
Okay, yeah, it looks good.
Thank you. It makes me look a little bit more, prestigious, so.
Absolutely. Oil paintings, definitely.
Yep.
All right, new. Oh, that's Marilyn. That's Marilyn Williams, new, right?
Yes, sir.
All right, well, we just keep it in here. All right, is Ali McCowan here? Anita Gilstrap.
Yes.
How are you doing?
All right, sir. How about yourself?
Well, I have you checked in with Ms. Hamoud. Well, not with Ms. Hamoud, but Ms. Hamoud is the plaintiff's attorney. Now, do you have an attorney, Ms. Gilstrap?
No, I spoke with one on my first initial contact, but I thought they were supposed to be here when the court case started back up.
Okay. Do you know who? Go ahead.
I'm not sure of her name, but it was a lady. We spoke on May 2nd.
All right. I mean, did she say she would represent you or only give you advice?
I believe it was just advice and trying to see if I qualify for their free.
Okay, this is what I'm going to suggest you do. Because if they can't represent you, they'll give you advice only. But see if you can work something out with Ms. Hamoud. She's the attorney for the landlord. If you can't, or if you request counsel, she'll send you over. And if they couldn't represent you last time, chances are they can't. But I'm not going to make that assumption. I'll leave it up to you. See if you can work something out. If you can, great. If not, I'm here. So.
Okay.
All right.
How do I get to Miss Hamoud?
Morning.
Thank you.
I'm going to invite you to room 3. I'm going to invite her as well. Awesome. All right, let's see if everybody has privileges. Ms. Davis, got your privileges back. Yeah, you're live. You're all the way live, Mr. Durham. Good afternoon.
Okay, that's good. Is the mic on? Can you hear me?
Absolutely.
Okay.
Yes, sir. All right, and what case are you checking in on?
I'm checking in on the riot address on the 12897 riot.
Right, RAID, right?
Yes.
That's
IAD.
I haven't spoken with Ms. Hamoud yet.
Okay. And are you representing Mr. Durham?
Yes, Your Honor, I will be.
Okay, what's the last 3 digits of that case?
372.
372, Creative USA Investments. Okay. I don't have you checked in, Mr. Durham, so I'll put
Thank
you on
you.
mute. Sit back and relax.
Yeah, thank you.
Well. Mr. Abularar. Andy Ball. It's Andy Ball here. Ali McCowan. Tony Morris Jr. Felicia Morrow.
Yes, I'm here.
All right, Ms. Morrow. Good morning. Good afternoon.
Good afternoon.
Let's see. Ms. Morrow, do you need to speak to an attorney?
Yeah, probably, yeah.
I'm going to invite. Can someone from Lakeshore hop into the Lakeshore lobby? I didn't really brief her. She's on the phone.
We can, Your Honor.
Okay, thanks. Thanks, Mr. Mayor. Ms. Hamoud.
Good afternoon, Your Honor. We actually have a resolution for a case ending in 6375 with Ms. Gilstrap.
Calling case number 2334-6375. This is Mapalu LLC versus Anita Gilstrap in all documents.
Good afternoon, Your Honor. Nasreen Hamoud, P number 80522, appearing on behalf of the plaintiff. And also present in the gallery is Ms. Anita Gilstrap.
Hello, Your Honor.
Hello.
Your Honor, we did have the opportunity to discuss a potential resolution. We have agreed to a move-out date of June 12, 2023. That will be via a judgment by hearing. The judgment will also include a separate provision stating that this matter is dismissed as to Ms. Anita Gilstrap. Is that correct, Ms. Gilstrap?
Yes, ma'am. I agree.
Okay.
Okay, we'll do a judgment. This is a judgment by hearing. Termination of tenancy case. What is the move out date again? June 17th?
June 12th.
June 12th, 2023. And all occupants must vacate by June 12, 2023, or a writ of eviction can issue. All right, so your name is removed as a named party. This will go on all occupants, but all occupants must vacate by June 12, 2023.
Yes, sir, and I am the only occupant.
All right. So, good luck. Enjoy your weekend. You should get something in the mail in the next week or so. And have a great weekend.
Thank you, Your Honor. Thank you, ma'am.
You're welcome. Best of luck to you.
Bye-bye.
Is Gloria George here?
Oh,
Good shot. Tomorrow, okay, I think. Mr. Benabo. Is Marche Simmons here? Marche Simmons. I call default judgments at 2:30. So for people who are waiting on defendants to appear, if you're the landlord and you're waiting for the defendant, keep an eye out. But I won't call the case and enter a default until 1 hour after. I give everybody an hour before calling defaults. So FYI, in the event you needed to know that information to plan your day accordingly. All right, is Donna Cheatham here? Is Attorney Weaverman here?
Your Honor, I apologize. This is Attorney Boyke. I believe Donna Cheatham is in a breakout room with some of our attorneys.
Okay, thank you.
Thank you.
Sure. Is the Kayleana Gaucher here? I'm sorry. The Kayleana Gaucher. Is Ray Shepherd here? Amanda Shepherd. Anybody on Fenton? Is anybody here on Riot? Oh, 12897, and that is 12897. 12897. All right, Mr. Mamet is not going to make it today. We're looking for an adjournment. Who said that? Robert Gatney. Okay, Mr. Gatney?
Yes, sir.
Are you the attorney for the plaintiff?
I'm standing in for Mr. Mamet, yes.
Okay, and you're seeking an adjournment on both cases?
Yes, sir.
Kayleana and Amanda Ray Shepherd?
That is correct.
All right, I'll call these then. How much time do you need?
Just 1 week.
We're not here the 18th and the 19th, so we could do the 22nd or 23rd. Or the 17th. The 17th won't get noticed in time.
The 22nd, it would work for us, Your Honor.
Okay. Calling case number 2334-6367 and also 2334-6369. This is Freedom Management Property Service versus Tekeliana Gaucher. That's case number 367. And Amanda Ray Shepherd. That's case number 369. May I have your appearance?
Robert Gatton, AP number 85167 on behalf of the petitioner, standing in for Stephen Mamet, Your Honor.
Thank you, counsel. Counsel, are you requesting an adjournment for until May 22nd?
That is correct, Your Honor.
All right, the court finds good cause to adjourn this matter to May 22nd, 2023. Should be enough time to notice the parties, and if defendants appear, the court will notify them of the new court date.
Thank you, Your Honor. Have a good weekend.
You're welcome. Some access, Mr. Keenan.
Oh, no, I just got a,
Oops. I'm sorry. I didn't mean to mute you.
there you go, sorry. Didn't realize I was muted. No, I just worked out, we have a conditional dismissal we can put on the record whenever the court's ready.
I think the court is ready. What matter is this?
This is ending in 362, River Point Tower versus Donna Cheatham.
Okay. On case number 2334-6362. This is River Point Tower versus Donna Cheatham. And all right.
And this is Kyle Keenan, P86413, Lakeshore Legal Aid, representing Ms. Cheatham.
Dan Weberman on behalf of plaintiff River Point Tower. We've reached a resolution, and thank goodness that Mr. Keenan was there present. Very influential and helpful in helping effectuate this resolution.
Ms. Cheatham, could you state your name for the record?
Donna Latrice Cheatham.
Thank you.
Thank you, Ms. Cheatham.
All right, so we are going to enter into a conditional dismissal. The due and owing is $794. That includes the fees. Mr. Weberman can break down those fees for the court and the record for us. And that will be due on or before June 9th. And that does include the June rent. So they are permitting it to be paid after she receives her disability payment. And that should be good. And Ms. Cheatham, do you allow me to sign on your behalf?
Sure, go right ahead.
Okay. And Mr. Weberman, I believe you will wait.
Is this a conditional dismissal?
Yes, so I'll be entering in this case and filing the CD with the court.
Yes.
Okay.
So Your Honor, the breakdown, I'm sorry.
No, go ahead.
The breakdown would be, there's 262 that plaintiff claims is past due. And then defendant has agreed to pay within the confines of this judgment her June rent of $262. There's a $110 filing fee, $125 statutory attorney fee, and the $35 service fee with your court officer, totaling $794 that the defendant has agreed to pay on or before June 9th, which will resolve this case and bring her current for June.
Right, is that your understanding of the agreement, Ms. Cheatham?
Yes, I do.
Okay, and if this is paid, this case is dismissed. In the event this is not paid, is 4B checked? Or 4A?
Yes, Judge.
Okay, 4B is checked. So, Ms. Cheatham, in the event this is paid, a judgment and a writ of eviction can be filed at the same time.
Yeah, they told me. Yes.
All right, okay, so the court is comfortable with entering this. Any questions?
No.
And obviously, we want to keep working with Ms. Cheatham and keep her as a resident here. It's less expensive that she pays, then we have to proceed with the eviction, and we hope they have a long and memorable relationship with her at this tenancy.
All right, that sounds good to the court.
All right.
Yeah, Ms.
Yes.
All right, well, you all have a great weekend. And have
You
fun.
too.
Say it all.
Thank you.
Attorney DeGard.
Yes, Your Honor, I thought I was ready, but I'm just now seeing some chats that opposing counsel's in a different courtroom, so we're not ready.
Okay. Ms. Hart, gotcha.
Yep.
Kamisha Webster. Ms. Hart, are you still, let's see, is Ms. Hart still here? Yeah, she's still here. Ms. Morrow just called me on the phone and she says she's logging back in onto Zoom. So she called the courthouse, she called the courtroom. She'll be logging back in.
Thank you, Your Honor.
So,
We'll watch for her.
all right. Mr. Price. So,
Excuse me, Your Honor.
Are parties ready on 532?
I'm not sure. Mr. Newton was in the gallery. As I stated, he's been having some health issues. It looks like he just left the call and he left the Zoom call and he gave me a call. He wants to know when the case will be called because he is having some health issues. I advised him to call right back, but I don't know if or when he will be able to.
Okay. All right. All right, let's recall this case.
Okay, I will ask him to call back in and let him know that his case is being called now.
Okay, and if he can't make it, we'll go.
Thank you.
May I speak? My name is Felicia Morrow.
Hello, Ms. Morrow.
Your Honor, if it's all right, I'll move Ms. Morrow back.
Okay.
Thanks.
Oh.
Yeah.
Excuse me, Your Honor.
All right. Party's ready for this to be called. Recalling case 22393532 LT. This is Woodbridge Senior Village versus Chauncey Newton and all occupants.
Good afternoon, Your Honor. Brian Gerda, P 80756 on behalf of the plaintiff.
Good afternoon, Your Honor. Lauren Lamonius, P 83053 on behalf of Mr. Newton, who is in the gallery.
And then Ms. Louise Dorsey, if you can go ahead and put yourself on camera. And Your Honor, I have here Ms. Louise Dorsey, who's a representative of the plaintiff.
Thank you. Good afternoon, Ms. Dorsey.
Good afternoon.
All right. We've had, defendant had a motion and brief for summary disposition. We attempted to get your defendant here. He was here previously.
Oh, he's here right now.
Okay. All right, let's restart. Can you swear your witness in?
Okay.
Okay, yeah, go ahead and swear.
Mr. Newton, he's on the telephone ending in 9604. Mr. Newton, will you please say your name for the court?
Jonathan Castro.
All right, thank you. Good afternoon, Mr. Newton.
Good afternoon, Your Honor.
And Mr. Newton, do you swear to tell the truth and nothing but the truth?
I do.
All right. Counsel. All right. Well, Mr. Newton, did you receive a notice to quit in the lawsuit? We're here for the current lawsuit, the eviction lawsuit. How did you receive notice of this lawsuit?
It was in the mailbox.
It was placed in the mailbox?
Yes, sir.
Okay. Did you receive, okay. I'm actually, this is not my motion, counsel.
Yes.
Please continue with
Okay.
your argument.
Yes, so Mr. Newton, notice to quit dated September 13th, 2022. You did indicate on the record that you received notice of the notice to quit in your mailbox.
Yes, I did. I received that in my mailbox. Yep.
Did you receive that notice any other way?
So I didn't. When they put those checks up under my door, it was in the beginning of the year. Then somebody was in the hallway about in February and handed me a new date notice because one of the dates got redid. That's the only time somebody handed me something was when the date got redid.
Okay, it appears that you're
That was
talking
this
about
year.
a notice to appear in court at a date
Yes.
subsequent to February 2023.
Yes.
Okay, well, Your Honor, I would again ask that this case be dismissed because the notice to quit that the defendant received was improper. I would like to state that the defendant's tenancy is federally subsidized and is governed by the federal government, and according to 24 CFR section 247B2, the notice that's served on the defendant has to be properly effectuated by being served both via first-class mail and by serving a copy of the notice on an adult person answering the door at the lease dwelling unit, or if not, the notice has to be placed through the door of the dwelling. The plaintiff did not serve the defendant, or the plaintiff served the defendant by first-class mail only, and by failing to serve the defendant or attempt to serve the defendant personally, proper service was not effectuated, and that does not give this court proper subject matter jurisdiction. So I would move to dismiss this matter.
Your Honor, response?
Sure.
As I stated previously, Your Honor, federal regulations are not law. Those do not dictate anything that happens in this courtroom. The defense counsel has cited to no law, whether in statute or case law or under Michigan law, that deprives this court of subject matter jurisdiction for properly filed summary proceedings action. The notice of the reasons why the defense tenancy was terminated was delivered to him He acknowledged service. He was on notice. Now, this is a notice pleading state. We operate under general principles that notice, as long as it's achieved, then everything else is goes smoothly, right? As long as you're on notice of what is going on against you. And that's exactly what happened here. He was on notice. Again, there's no law that deprives this court of jurisdiction for a properly filed complaint. And if we need to go further, I can bring in, I don't have any personal knowledge of any individual that would have tacked this notice on that individual, on the defendant's door. But if the court, for whatever wants to explore this regulation, I mean, if I can say it differently, Your Honor, this is a regulation that is not law, it does not apply to this case. The defense counsel could be citing to a magazine they pick up off the bookshelf and try to call it law.
It's in the Michigan handbook. It's 24 CFR 247.6A. If you can show me where it doesn't apply, it's in the landlord tenant bench book as the manner of service. It's not just, this is for federally regulated housing, for housing with disabilities and housing for people with disabilities, section 202 and section 811. So it's 42 USC 8013A states the purpose of section 811 is to enable persons with disabilities to live with dignity and independence within their community by expanding the supply of supportive housing that is designated to accommodate people with special needs, makes available supportive services that address the individual health, mental health, and other needs of such persons, and promotes and facilitates community integration for people. And it goes on. So it's not just, it's.
What section, sorry? So I'm pulling it up. What section of the handbook?
This is referenced as section 202, section 811. And this will be 42 USC 8013A. I think this is the persons with disabilities.
And this is the 2023 residential landlord tenant law bench book.
Here's the bench book. But okay, I'm saying that I made that point because it's not just out of the blue. It has some weight to it, but defendant had notice. And if we're relying on this, we also have to give some weight to the amount of time. This case was filed in November. How is your defendant harmed?
How's the defendant harmed?
How's your defendant harmed? What harm is being caused by the defendant by me not dismissing this lawsuit?
What harm? State that again one more time, Your Honor.
How is your defendant affected by this failure to provide notice in writing, personally?
Yes, he did not. He did
in writing, and it was also a paragraph. It's an addendum to the notice to quit that was presented. It says, "Dear tenant, pursuant to MCL 5541.3 and 24 CFR 248, you are in material breach of your lease agreement and your tenancy is hereby terminated. You have the right to reply to this termination as you wish." And it's a full breakdown of what's going on. However, it wasn't personally provided based on testimony of the defendant. But okay, what's the harm?
Yes, Your Honor. When the defendant initially received the notice and then initially received the summons, the notice or the reason that the plaintiff stated that they had filed the complaint was for alleged harassing activities. It is now, this case was initially filed again in September of 2022. It took several months for us to get an understanding of what exactly was being alleged. I've requested from plaintiffs several times more information about what the alleged harassing activity was. The plaintiff did state earlier on the record that on May 3rd, they finally sent some kind of documentation backing up what their claims are. I still have not received those documentation. I do not know what those documentations are.
Let's go over the claims. What are the claims of improper behavior? What are those claims?
Harassing activity is what was alleged.
Okay, what's the harassing activity? May not be an issue if we can figure it out right now.
Apparently, on May 3rd, more information about those harassing activities were sent. I don't know if they were sent to me or sent to the court, but I do not know what they were.
Are you answering this question? Are you answering this question because as plaintiff counsel and you're
excuse me, go ahead.
Just saying that, oh, more documents, apparently more documents. You're trying to, it sounds, you all want to fight. Let's get this case over with.
Amen.
Yeah, I'll articulate just very punctually here. I didn't hear an answer to your question about what harm, and the answer is there is none. He was on notice of the behavior. He received it. He was given his rights to file or ask for a grievance hearing and whatnot. He had all that back in September of 2022. This case was filed in October. We filed a response to the motion for summary disposition. That response had 3 incident reports on it. Those were the same documents that I found in our file for the 3rd. There's nothing new. There's nothing to add to that. 3 incident reports of the harassment that has occurred at this property. I have 3 witnesses to testify today as to ongoing harassment at the property. That will be established in the plaintiff's case in chief in detail.
Okay. And did you receive a copy of those reports, Mr. Moniz?
I received copies of incident reports, yes, Your Honor. At the last hearing, when we were here with Attorney Wilburn, I did indicate that it is Mr. Newton believes that this case stems out of repair issues in his apartment and the way that management was handling those repair issues and because of Mr. Newton's disability, that the management did not properly or give him the properly come to his apartment building. And that's where these allegations of harassment stem from. At that last hearing, I did indicate that I had asked plaintiff's counsel for further documentation regarding inspection reports in Mr. Newton's with Mr. Newton's apartment, information about Mr. Newton's disabilities and what plaintiffs or what the property management would be doing to address those concerns about his disability. And those were the documents that I was expecting to receive by the hearing today so that we could explain or figure out what exactly was going on with those notices about Mr. Newton's alleged behavior.
Okay, so you have someone who can testify, Mr. Gerder. There's a
Yes,
notice
3 individuals.
September 1st, 2022. There's one from September 6th and one from September 7th. So
And that's the tip of the iceberg. Those are the written notices. They're also going to testify to what the reality of the situation is, the ongoing reality.
All right, and do you have someone who can testify to that, Mr. Gerder?
Yes, Your Honor.
All right, and can that person state their name?
Your Honor, it was my understanding that today we were still in the pretrial phase. Mr. Newton also has some witnesses on his behalf. They are not here today, however, because I was under the understanding that we were still in pretrial discovery and that the hearing was not set for today.
I can still make a determination on this. We made a determination on everything else. The parties are here. This is summary proceedings. I mean, where are we going to go with this landlord tenant eviction? Can you please have your, your person is here she can attest to what happened and he can respond to it. Nobody else would have the knowledge, would they, to, I mean, if you want to add more testimony, we got have an additional hearing, but the parties are here. I'm not delaying this anymore. Because there's a benefit to the delay, Mr. Monius.
I do understand that.
There's a benefit to the delay. I keep delaying it. It's more benefit. It's a benefit to you. So you're claiming harm, but really you got 6 extra months.
Yes, Your
So-
Honor, it is really only the delay, I believe, because we have not received evidence of Mr. Newton's
I'm about to get it right now. I'm about to get it right now. So can you please voir dire your client?
Yes, Your Honor. Ms. Dorsey, can you go ahead and unmute yourself and state your name for the record?
Louise Dorsey.
And can you please state your relationship with Woodbridge Village, Woodbridge Senior Village?
I'm the acting manager.
All right, and what are some of the responsibilities and roles with that job?
Regional manager.
And what can you describe to the court what you do?
Day-to-day operations, process grant, handle all concerns for the property.
Okay, are you familiar with the address at 3701 Miracles Boulevard, number 401?
Yes,
And how is it, are you familiar with that property?
it's one of the apartments in the building.
Okay, does Woodbridge Senior Village own that property? And manage it as well?
Yes,
And the defendant Chauncey Newton, are you familiar with that individual? How is it that you're familiar?
he's a resident in that apartment.
I didn't catch the last part of that.
He's a resident at that apartment.
He's a resident at unit 401.
Yes,
And are you familiar with the notice to quit, a document that, let me pull it up here real quick. Are you familiar with the document called notice to quit?
yes.
That was delivered to, well, let me just back up. Are you familiar with a notice to quit that was issued to Mr. Newton?
Yes.
Can you explain to the court what the reasoning was behind that notice to quit?
An altercation that occurred with Mr. Chauncey Newton and staff here at Woodbridge Senior Village. He was
All right.
very,
Sorry, let's get detailed here. So let's talk about September of 2022. We'll start there and then move forward chronologically. So
Okay.
starting in September, right before that notice was issued, can you describe to the court in detail what happened between Woodbridge and Chauncey Newton?
when I got there, the manager who was here at the time, Asia Johnson, had called me and told me there was a situation going on in built at 3701 Miracles Boulevard. And Chauncey Newton was being belligerent. He was launching at her, and he had already had an altercation with maintenance. When I got there, Chauncey Newton had removed himself from the situation. The police was called.
Okay, now going forward from September, has there been any other altercations or disagreements or incidents with Mr. Newton?
Yes.
Can you please describe those to the court and take your time?
Chauncey Newton had another incident with another staff member, maintenance, and he was making idle threats to maintenance, and maintenance was asked to remove himself from the situation. There was another situation where Mr. Newton had gotten to a verbal altercation with the welcome desk, and that's the other residents that sit at the front desk and greet the visitors. He called them all kinds of names. And another situation with myself personally with Mr. Newton, I hadn't seen him, didn't know who he was. And he was in the lobby and having an altercation with one of the maintenance guys. When I found out who he was and he knew who I was, he started walking towards me, calling me, "Oh, you're Louise Dorsey, bitch, I've been looking for you." you've been avoiding me for the last 8 court hearings, and now I see who you are, and they ought to have your job, and I'm gonna make sure you don't have your job. And he just started calling me all kinds of names and walking towards me. I asked the security guard to call the police, and I started walking away. Another situation was recently, May 4th, I was doing inspections in the building, and Mr. Newton's unit was one of the units I had to do inspection of. He has a dog, an unauthorized dog, and when I was standing in the hallway, the dog was coming towards me. He pulled the dog back, but he was looking at me and holding the dog as if he was going to let the dog go. I exited the stairwell and left the building. They did send Mr. Newton an infraction letter in regards to that. Mr. Newton is very threatful. His demeanor, his behavior, he feels that he's untouchable. He says anything to anyone and anything in the building. He has no respect for any of the seniors in the building. When they see him, they go the other way. He is a very, very threatening person. And as far as work orders, we haven't received any work orders from Mr. Newton. And at this point in time, I don't think maintenance is willing to enter his unit because of his behavior. And if it was, I would have to send 2 people in his unit to do the repairs. But like I said, we have not received any work orders. But Mr. Newton is, he is, I can't describe his behavior. He is, it's just unbelievable the way he carries himself. As a person, as a man, he calls anyone out their name just no regards. It's just unbelievable.
Did you mention some vulgar language too?
Yes, he's called me bitches and hoes, and I'm gonna make sure you don't have a job.
I have to
Mr.
interject.
Newton, please be quiet.
Please, boss.
Okay, sorry about that, Ms. Dorsey. And now you mentioned about creating incident reports. Could you elaborate on your system that you use to make incident reports?
We send infraction letters whenever there's an incident on the property, and it'll cite different things: disturbing or damaging the property, disturbing or harassing of other tenants, staff, things of that nature, unauthorized dogs, unauthorized occupants, altering the unit without management approval, things of that nature.
And you're familiar with the books and records that Woodbridge Senior Village keeps, correct?
Yes.
Are you familiar with the notices of infractions dated September 1st, 2022, September 6th, 2022, and September 7th, 2022?
Yes.
And to the best of your knowledge, do the form and content of those documents comport with the process that Woodbridge keeps in recording incidents?
Yes.
Okay. No further questions from this witness, Your Honor.
Yes, Ms. Dorsey, you mentioned in the beginning an incident with an Asia Johnson. What date was that?
That would have been September 1st.
September 1st. So is it fair to say that the incident report that was entered on September 1st, where you all checked that Mr. Newton had been disturbing and harassing other tenants, security, or staff, and activities calling the police was the only incident report filed out of the events of that day?
That particular day?
Yes.
Yes.
Okay. You described an altercation. Was this altercation verbal or was this altercation physical?
The first one, when I got there, Mr. Newton had removed himself from the situation. Ms. Johnson did tell me that she had to bag up because he was launching at her.
So the altercation may have been almost a physical altercation, but not quite.
I would say yes.
Okay. You said the police were called that day.
Yes.
Was there an associated police report?
No, they said they were just going up to talk to him. He was intoxicated and they did not remove him from his apartment because he had went back to his apartment. And I'm assuming he told them that he was going to remain in his apartment, but there was no police report.
Is Mr. Newton's intoxication something that you determined, or how would you know he was intoxicated at that time?
No, that's something that the police said to Ms. Johnson.
Okay. You did also mention that there were no work orders filed by Mr. Newton. Are these work orders after a certain day, or were there no work orders ever filed by Mr. Newton?
I'm not saying that there were work orders ever filed by Mr. Newton. Since I've been here, and I've been here for about a year now, and I have not seen any work orders come from Mr. Newton.
So you've been with the company since about May of 2022?
No, I've been with the company longer than that, but I've been actually here at this site.
And since about May of 2022?
Well, prior to that, I was here for about 6 months, pulled to another site, and I got pulled back here.
So could you describe the process for making work orders? Are these written work orders, or are these something that the residents call down to give to you?
The residents call the office and staff will create a written work order.
Okay. So it's fair to say that after May of 2022, Mr. Newton has never called or visited the office to request work orders.
I cannot say that because I have not looked at his work order history. I know he has not been in the office.
Okay. Has his work order history been provided? You haven't looked at it. Do you have record of that?
I can get a record of that.
But you don't have that yet.
Correct.
Okay. There are two in addition to the notice of infraction that was provided for September 1st. There's one provided for September 6th, and there's also one provided for September 7th. Do the infractions arise out of the same or different incidents?
Different incidents.
Okay. Thank you.
You're welcome.
Nothing for me for this witness, Your Honor. Ready to call the next one.
Okay. Mr. Moniz.
Yes, Your Honor.
After the testimony of Mr. Gertis, witness, do you still need further information, discovery related to the incident?
Yes, Your Honor, I would like the history. I would like to see Mr. Newton's file. I would like to see any work orders that he has previously requested. I would like to see what the apartment complex, if any, has been aware of any disabilities that Mr. Newton has had. I would like to know when folks were sent to Mr. Newton's apartment. Miss Dorsey did indicate that since she has been been on site since May of 2022, that Mr. Newton has not filed any work orders, but I do have reason to believe that, or information on and belief, I believe that some workmen had come to Mr. Newton's apartment just before these notice of infractions were filed. So I would like to see when his apartment was visited by staff of the building.
Is that information available?
If records are kept properly, I believe it may be.
Your Honor?
Sure, can we find out if that information is even available?
Right, which would be directed on my end.
Sure, yes.
So first I have to say, Your Honor, that fishing expedition and irrelevant information. Work orders have nothing to do with my client's superior right to possession of this property. they want to fish around to try and build some counterclaim, it's too late. All right. If they have no legitimate reason to believe any sort of discrimination, I mean, that a fishing expedition written all over it. Now, to the court's question, what is it specifically, if relevant, I need to produce still, and we can get that done right here so we can continue this hearing. I got 2 more witnesses to call for on case in chief.
All right.
Apologies, Mr. Gardner. Would you please restate that?
Restate everything I just said
No, just the last sentence.
about having 2 more witnesses to call?
No, just before that. I heard everything except for that just before that.
I'm sorry, not sure what sentence you're referring to, but I was just saying, I think I was asking the judge what specifically we were looking for that's relevant, and then I said, I can get it together real quick so we can keep proceeding with this hearing. If it's relevant to the hearing, of course.
Yeah, I mean, this is, I mean, the court feels like defendant has had adequate notice. I mean, it's a repair issue. When we got through the notice, now it's repairs. You can call your next witness.
Thank you.
Your Honor, may I speak?
Sure.
Yes, in my response, in my initial motion to dismiss, I did also provide documentation or comment regarding our belief that Mr. Newton does have a disability and some of the protections that are available to him because of his disability. That is why when discovery was initially opened, I asked for all of the documentation that would allow us to build a case. It is my understanding that we are still in discovery and not ready for a full-on trial. And the reason why discovery needs to be continued is because we believe that there is more information that the apartment complex has about the condition of Mr. Newton's apartment, about any disability that he has, but I have not been able to get that information from plaintiff's counsel as of yet. I do believe that it is still relevant, and this is not a delay tactic. These are documents that I have been requesting for some time. Mr. Newton additionally does have witnesses that can be called, but because it was my understanding that this was still pretrial, his witnesses are not present at this moment.
I'm ready. May I proceed, Your Honor?
Sure.
All right, plaintiff calls Harry Reynolds next. And I believe they're going to be sharing the same screen, so we won't have to admit anybody else in.
All right, hold on. Okay, go ahead. Go ahead. Let's continue with this.
Good afternoon, Mr. Reynolds. Can you please state your full name for the record?
Harry Reynolds.
And how are you associated with Woodbridge Senior Village?
Maintenance man for Senior Village.
How long have you been in that role?
Since July of 2022.
And are you familiar with the property at 3701 Miracles Boulevard, number 401 in Detroit?
Yes, sir.
And how is it that you're familiar with that property?
That's the building I'm in charge of as far as maintenance.
Are you familiar with any tenants that live in that unit?
Yes, all of them.
What are they? Just 401.
401, that's Mr. Newton.
Okay. And in the sense, let's just go back to September of 2022. Have you had any interactions with Mr. Newton?
Yes, I have.
All right, please take your time and just describe to the court the nature and dates of those interactions from September of 2022 going forward.
I don't know the exact date, but I know the month of September, after I started, we were doing inspections. And me and one of my coworkers were walking around doing inspections and knocked on his door. And he opened the door and basically cussed us out, hollered at us, told us he was going to cut us and shoot us, and slammed the door in our face. So we reported that to the office. And every time he had a work order, after September. Every time he had a work order and we go to try to do the work order, it was the same thing. He's very belligerent, very disrespectful. No matter how we tried to help, he just loud, don't want to listen, cussing us out, telling us what he's going to do to us. He confronted me after that at least 3 more times, continuously throughout me and being employed here in the lobby, trying to fight me, telling me he's going to shoot me and all kind of other stuff. So I reported it to the office and I let them do whatever they needed to do.
Did you smell any alcohol in any of these interactions?
No, most of them, yes.
Any other, I think you covered, and no further questions, Ron.
Okay. Would you like
Oh,
to
stand by, sir. Not from me, no questions from me, but there might be more.
Mr. Reynolds, you said
Yes.
you are familiar with Mr. Newton. You do
Yes.
not remember, you've been to his unit several times, is that correct?
Yes.
You do not remember the dates that you were in his unit,
No.
but the incident where you described where he slammed the door on you, the one you just talked about, do you have a rough date range of when that might have been?
September, the beginning of September. We were just doing our inspections for the buildings.
Okay, so when you do inspections for the building, do you do those inspections on any kind of schedule?
Actually, yes, we do. All the tenants were notified that we will be there, that we will be doing inspections. So we have to go and do our inspection. So me and another coworker went to his apartment to do the inspection.
So when tenants, or I guess what I'm asking, you did say you notified the tenants that an inspection was coming. Do tenants, for example, have an inspection every month, every year, every quarter? Is there any type of pattern to when inspections occur?
It's through DHC. That's how they schedule everything. Do it through DHC. So they schedule it through DHC. DHC notifies them, and then they notify us when we can go in.
So is it like twice a year? Is it more often than that? Is it every month? Is it every week? Or is it when the tenants call you and tell you they would like an inspection?
No, it's mandatory. At least I would say at least 3 times a year. It's mandatory.
At least 3 times a year, it's
Yes.
mandatory.
Yes, it's
Okay.
mandatory.
And so when you complete the inspection, is there any paperwork that you fill out before you do the inspection or after you do the inspection? And if so, is that something that you turn into the front office?
The only paperwork we do is what we were sent in here. We have to fill out what we fixed and modified in the apartment.
Okay, so do you have like a sheet of paper when you go
Yes.
into a unit?
Yes.
And then you'll check off what you did?
Yes, every unit is pre-inspected before we even get a work order. So once it's pre-inspected and we get the verification to go ahead and do the work order, that's what we do. Go knock on the door to notify our tenant that we will be coming into their unit.
Okay.
They usually get paper notices to let them know that we will be doing inspections and we will be doing our repairs through a certain period.
Okay, so the pre-inspection, is that something that is issued from the apartment complex, or is that something that is issued from DHC?
Both.
Okay, and that's on a sheet of paper?
Yes.
So if you were, for example, I know you said you weren't able to get into Mr. Newton's unit, but if you were, you would have had a sheet of paper and you would have checked off that you've completed the work. Is that correct?
Yes.
Okay, so did you have a sheet of paper after or when you went into the unit on September 1st that you didn't get to complete?
Yes, we yes, we did. We got the paper.
And is it your pattern to turn that into the front office for record keeping?
Yes, you do.
Okay, and so you
turn
did
it in
say,
you turn it in for record keeping. If the tenant denies the service, you have to turn it in. You have to state what happened and why they denied the service and everything. And then we let the office deal from that through the clerical side of it.
okay, so it's fair to say that you have a sheet of paper that would have told you or that would have indicated that Mr. Newton denied the service that you would have turned into the front office?
Yes, ma'am.
Okay, and then you would have done that each and every time you went back to his unit?
Yes, ma'am.
And you said are you new to the building, or you only September was the first time you entered into that room, or you attempted to enter into that room?
September was the only time I attempted. I started in July. September was the time for the inspections. When I got there, I didn't know none of them, no names, no nothing. I just knew them by apartment numbers.
Okay, so it's, so
Knocked on
you're,
his, we knocked on his door to let him know that we were there to do the inspections and do the repairs. And we basically got cussed out, threatened, and the door slammed in our face.
okay, so is it fair to say that the paperwork that you turned in would have shown what time of day that you, or the time of day that you attempted to enter Mr. Newton's apartment?
It actually wouldn't show the time of day. It just showed the date that we were required to go in there to do the repairs.
Okay, and would the paperwork then show the pre-inspection? Would that show whatever problems of repair that Mr. Newton had in his apartment before you attempted to enter it?
Yes, ma'am.
Okay. Is that something that you remember seeing beforehand, or did you know of any problems in his unit that you were expecting to fix on that day?
No, I seen it on the paper.
You just don't remember what that was right now?
No, I don't. I'm trying, but no, I don't.
Thank you.
Nothing further, Your Honor. From this witness. Okay, thank you, Mr. Reynolds. The plaintiff next call Stacy Lewis.
Who?
Good afternoon, Mr. Lewis. Can you state your name?
Stacy Lewis.
And what's your relationship with Woodbridge Senior Village?
I'm a maintenance tech at building 404 at Woodbridge Senior Village.
And can you describe to the court what being a maintenance tech there entails?
It entails doing building repairs, work orders, resident work orders, grounds, snow removal, and things of that nature.
Are you familiar with the property, the unit at 3701 Miracles Boulevard, number 401?
Very familiar.
How is it that you're familiar with it?
My first encounter there, we went there to do inspection work.
Sorry, let's just back up. Generally speaking, how is it that you're familiar with that unit? Part of the job, you know?
Yes, part of the job. Okay. It's part of the job. I was assisting someone at the time. Yes.
Okay. And you mentioned your.
I'm sorry, Mr. Gerda, Mr. Lamonius, this is pointless, in my opinion. I'm going to dismiss this case. Mr. Gerda, you're free to refile this matter. File a police report, and in the instance that incidents happen, this is a fishing expedition. It's slowing down the docket, and I'll let you all continue this testimony, but I want to get the other lawyers out of here and the other tenants out of here. We can continue on for the rest of. I'm dismissing this case. I made a decision.
Can I have a grounds for dismissal when I'm not even finished presenting my witness testimony, Your Honor?
Let's just pause this then. Let's pause this. I'll give you a grounds for dismissal after this, but sufficient expedition by the defendant, and we're never going to get to a judgment in this case, in my opinion. So we're gonna let's hold off on the testimony. Hold off on the testimony. Briefly, we're going to take a break. I'm going to try to get the other attorneys out of here, and then we'll restart this testimony. Excuse me for interrupting your testimony. And I'm not going to dismiss this case until I've heard the rest of the testimony. Okay? So I'll strike that from the record, but.
Thank you, Your Honor. May I be placed in a breakout room with Mr. Newton, please? Telephone number ending in 9674.
I'll give you calls privileges.
Louise, please mute and turn off your camera.
Our party is Marilyn Williams, is 786 ready to go?
I am not sure if opposing counsel is back from Judge Brew's courtroom. Yeah, it's Miss Hart.
Okay. Is Ali McGowan and Andy Ball here?
Yes, Your Honor.
All right, is Andy Ball here?
Andy Ball is not here.
Is Tony Morris Jr. here? Calling case number 2334-6350. This is Ali McCowan versus Tony Morris Jr. and all occupants on Holcomb Street. Can someone please state their name for the record?
Ali McCowan.
All right, thank you. Mr. McCowan, are you the owner of the property at 5057 Holcomb Street?
Yes, I am, sir.
All right. Is Tony Morris here, Jr.? And did you have this file? Did you have this complaint, sir?
Yes, I did. And I faxed that over to the I forget the number, along with the deed to the property.
Okay. Okay. What are your requests? Is Tony Morris? Go ahead.
I just want the person. I want them evicted from the property, sir.
Defendant failed to appear. Default judgment is granted. Defendant must vacate by May 22nd, 2023, or a writ may issue. Please submit a judgment to the court.
Thank you.
You're welcome. Our party's ready on Felicia Morrow.
Your Honor, this is Elise Boyke with Lake Shirley Glade. I spoke with Ms. Morrow as advice only. I was hoping to speak with opposing counsel, but I think we may be able to get this resolved. But I believe he's been kind of hopping back and forth between courtrooms today. So I'm not sure if it'd be easier to do an adjournment and have us work it out after.
Is it like advice only? Is advice? I mean, your advice only. So
well,
you're like you're representing her at this point.
Pardon?
I mean, you're representing her if you're advocating for an adjournment and speaking to opposing counsel. What's the difference of representation?
Well, I initially wasn't.
The law, the practice of law here, in a sense.
Mm-hmm.
Not your circumstance specifically, but that's just how I feel right now. So,
Your Honor, the only reason I say that is because I need some documentation from opposing counsel that I haven't gotten. Usually, we like to see that kind of information before we, accept a case for representation. So if you can provide that, I think
that's the third hearing. This is going to be the third hearing on the summary proceedings. These are summary proceedings. Look at all these files I have. I have files, more files. You have nothing but files. I'm tired of adjourning stuff for the inevitable.
Your Honor, I was just putting that out there because I know the other attorneys in another courtroom. I have no problem waiting and trying to work something out with him. I don't have anything else to update with this case currently because we haven't had a chance to speak with opposing counsel.
Okay. But you're not representing her.
Again, Your Honor, I haven't gotten the documentations. If you want me to represent her, if that helps the case, then I can do so. I just don't have enough information to comfortably, put that on.
Understand. Calling case number 2334-6358. This is Abdulrar Benabo versus Marsha Simmons.
Yes, how are you doing? Can you hear me?
Yes, I can hear you. Good afternoon. It's Marsha Simmons here.
Okay, I received the key from her on May the 4th, and that's it. I don't know, because you guys sent me a letter to for a new date, but she already gave me the key on May 4th, but she haven't paid me the money. So what do you want me to do? Just drop the case? Because I don't need the money from her.
All right, so we can dismiss the matter.
Okay, what did you say?
We can dismiss the matter. Would you like to dismiss it?
Yeah, okay. I'll give her a call and let her see if she could help me. Like if she could pay a little bit from the money. I'll see what she's gonna do about it.
If she's vacated, this is an option where you can pay or vacate. There's a money
She already
judgment.
vacated. She already left from the house, and I got the key.
Okay. All right, so I'm going to dismiss this matter. It doesn't preclude you from filing a civil claim to recover the proceeds of the money. Or you can request a default judgment and get a money judgment, but the option is to either pay or vacate, and she's vacated, so.
Okay, so I'm good right now?
Yeah, the court's calling case number 2334-6358. Abdulrar bin Abdul versus Marsha Simmons, an occupant from Dean.
Okay, so I could leave the meeting right now, sir?
Can you state your name for the record?
Abdulrar Abdul.
All right. And has vacated the property.
Yeah, she already vacated. She gave me the key on May the 4th.
Okay. The court's going to enter a dismissal without prejudice.
Okay.
This matter is dismissed. However, you may still file an action for a money claim and general civil if that's your desire.
Okay, thank you, sir.
You're welcome. Ms. Hamud?
Yes, Your Honor, we are ready for a matter ending in 6372 with Attorney Connor Brown.
Calling case number 2334-6372, Creative USA Investments versus All Occupants.
Good afternoon, Your Honor. Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Afternoon, Your Honor. Connor Brown, P79949 on behalf of the defendant.
Thank you.
And that's Mr. Durham. By the way, it's an all occupants case, but Mr. Durham is here. He's muted.
All right, thank you, Mr. Durham. You can stay muted. We spoke earlier. I know you are the occupant on Riot. Let's see. All right, counsel.
Yes, Your Honor. Unfortunately, we were not able to reach a resolution. It's my understanding that it's Ms. Durham's claim that he actually purchased the property under a land contract. I will allow Brother Counsel to go into more detail regarding those allegations.
Thank you, Ms. Hammoud. That is correct here, Your Honor. It's an unusual case. Mr. Durham signed a contract with someone named David Clarkston. The contract is on the plaintiff's letterhead. And it's a land contract for the purchase of the property in question. Plaintiff contends that there is no David Clarkston who was authorized to enter into that contract. Mr. Durham unfortunately paid $5,400 as sort of a down payment, and then made 2 subsequent payments to PO boxes that as he was directed by Mr. Clarkston. You know, I just feel like my due diligence here is to make sure that this is just the scam that plaintiff is suggesting it is, and it may well be that Mr. Clarkston had no affiliation with plaintiff. In fact, that's probably likely. But I do think that having an opportunity to investigate and confirm that would be appropriate under the circumstances. Mr. Durham's put a lot of money into the house, put a lot of money towards the purchase of it.
I'm okay with the adjournment, Mr. Mood.
Your Honor,
Are
just a quick point here. The quote unquote land contract that brother counsel emailed to me on its face is invalid and should not be deemed to be a land contract. The most important issue is that it's not signed. It does not contain the signature of any party. And I was not provided with any receipts that would prove that Mr. Durham allegedly made those payments. So I think that an adjournment would be completely unnecessary, and it would be unfortunate for my client. I did propose to brother counsel that we would agree to provide Mr. Durham until June 20th to vacate the property. I forwarded a copy of that contract to my client. They have no idea where it came from, and they are denying having any involvement in that document, and they were not even aware of Mr. Durham's identity.
So, Your Honor, just to respond to that, the contract does bear Mr. Clarkston's name and Mr. Durham's name on the signature lines, what are very clearly signature lines. The names are typed rather than handwritten, but I'm not sure that necessarily makes them per se invalid as signatures. And it's also true that Mr. Durham did not get a receipt for his $5,400 down payment, but there is a recitation in the contract itself that states seller has received $5,400 from buyer. So, you know, we're not dispositive on the legitimacy of the contract, but I certainly think that it's enough that it warrants an adjournment for a little further investigation. I'm not trying to make a huge case of this, but what I'd like to do is subpoena the post office to see who the PO boxes where the payment was sent, see who those boxes were registered to, and get, I guess, maybe a list of employees from Ms. Hammoud for the plaintiff, and just cross-check them. If we can't find any connection there, then yeah, it would certainly look like this was just a scam that had nothing to do with plaintiff at all. And I think that'll be sort of the end of it as far as possession is concerned.
All right. How much money was paid? And when was it?
$5,400 was the down payment, and then Mr. Durham, if you could unmute, I'm not sure.
Yes, I'm here. No, he just take that off. You talking to me? He just said. Okay, go ahead. Proceed.
Mr. Durham, the judge was wondering how much total you had paid. I mentioned the $5,400 down payment. What were your other 2 payments that you made to the PO box?
When I moved here, here's my kids here. When I moved here, I'm gonna tell you right now, we have this stuff on video. My neighbors have video cameras. I did a walkthrough on his house. I'm being taken for my money. These people is sending people to my house. I have a patient in the hospital because I got them. If we're in court now, why are they sending their claim company over to my house? I have a video here in my hand that states that, and I also have a video from my neighbors who actually see me do the due diligence with the ordeal.
Mr. Durham, could the judge, let's stay on point. He was trying to figure out how much you had paid.
I paid an amount of $5,400. I paid $600 for the lawn to have this whole house was abandoned and clean it up, and
we're just talking right now about payments to Mr. Clarkston.
I have a total of almost $8,000 involved right here, right now.
Just payments to Mr.
I'm gonna cut everybody off. We're adjourning this to May 17th at 10 a.m. Please have all documents prepared, a resolution.
Your Honor, can I ask the court for a slightly longer adjournment than that? If I have to subpoena the post office, I'm not sure that I'm going to get anything back from that day.
Your Honor, I could also propose to have an agent from my client's company available. I think the post office issue would be irrelevant because the issue we're trying to determine is whether this individual was associated with my client's company. That could easily be proven via testimony from my client. It's the inquiry here is not to figure out who this third party necessarily is. We just need to figure out whether he has any ties to my company.
Right, which figuring out who the post office boxes are registered to, i.e. where the money went, if there's any connection there, whether.
How long does that take, Mr. Brown?
I'm sorry, Your Honor?
I think that's gonna take too long.
If there is a connection between the PO boxes though and plaintiff, even if that seems unlikely, that would change things substantially. I'll just say that.
But it would be a determination that I wouldn't even be able to make. Once I find out it's a land contract, then it's an ownership issue that I don't have jurisdiction to determine who has the right to evict.
Well, then you dismiss the case.
What's that?
Well, then you could dismiss the case, Your Honor, and we could resolve it in circuit court.
A dismissal would actually.
Sure. It's premature. That'll be sure right now. It's like,
I'm not suggesting you do that now, Your Honor. Just that,
I did ask, and you gave me an answer.
But I do really think that at least figuring out who the PO boxes are registered to would be beneficial, and it would be relevant to the question of, whether there's any connection, whether the plaintiff received any of this money, or whether the contract is valid.
Mr. Moore, you said you could have a representative available on May 17th?
Yes, Your Honor.
Okay, let's do what we can do, Mr. Brown. I will grant you an adjournment to May 17th, or maybe even May 22nd. It's May 22nd. Let's do May 22nd. That'll give you more time. And try to prepare as much as possible. Sometimes it's not as much time as it would take to subpoena the post office, but we're in the summary proceedings courtroom, and we have to keep these cases moving at a summary proceedings pace and not at a general civil pace, because that's what it is. And
looking for due process here. I do understand that the time constraints are a little different, but again, I think
you can do process. You can do process.
Very good, Your Honor.
All right, I'll see you all back on the 22nd.
Oh, and Your Honor, will the court open up discovery just so I can request records from this?
You all can, yes, I'll open up discovery and allow this period. Actually, this is, discovery is open. You don't need an order in
Great.
district court. You may proceed.
Thank you, Your Honor.
Can you also make the honor aware that I may be in the hospital? I don't know if I'll be having surgery. I have to have spine surgery. Let's not forget that I'm in a robot wheelchair here. Okay, and I don't have the resources that regular people have. So I would like y'all to keep that in mind, that I am a needy, and I'm in a robot wheelchair here, and I'm on all types of medication, and I'm having a hard time staying up, just keeping up with you guys right now on this video.
Okay, if you're standing up, you need to sit down. Please sit down. You have to cut
No,
your
I'm
camera
in a
off.
wheelchair, sir. I'm in a power robot wheelchair, sir.
Okay, all right, and we hope that surgery goes well.
Yes,
And,
sir.
all right, and we'll take that in consideration. You do have representation, so any event you can appear, Mr. Brown can advocate on your behalf, Mr. Jordan. We'll take that
Yes,
into
sir.
consideration.
Thank you, Your Honor.
Yes, sir.
Thank you,
Your Honor.
thank you, artists. You're welcome.
Your Honor, am I able to put some defaults on the record? I have 3 matters ending in 373, 374, and 376. It does not appear that anybody is present for those matters.
Absolutely. Calling case number 23346-373. This is HTT and Co. LLC versus Kamisha Webster and all occupants.
Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Thank you. All right, is Kamisha Webster here or anyone from 14869 Freeland? Counsel.
In that case, Your Honor, we are requesting entry of a default judgment.
Default judgment is granted, then it must vacate by May 22nd or writ may issue.
Thank you, Your Honor.
Calling case number 23346-374, Kennedy's Constructions versus Zenobia Ellis and all occupants.
Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Does anyone reside at 14910 Retirement, Unit 410? Defendant failed to appear. Counsel, are you requesting a default judgment?
Yes, Your Honor.
Default judgment is granted. Defendant must vacate by May 22nd, 2022, 2023, or writ can issue. 374. And 23346-376. This is Jermaine Smith versus Gloria George and all occupants.
Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Thank you, Mr. Move. Is Gloria George here?
In that case, Your Honor, we are requesting entry of a default judgment.
Default judgment is granted. Defendant failed to appear as proof of service in the file. This is the complaint to recover possession of property. No amount to redeem. Defendants must vacate by May 22nd, 2023, or a writ may issue.
Thank you very much, Your Honor. I believe that's it for me.
Thank you. You have a great weekend.
Thank you so much. You too.
Judge, are these two adjournments at 10 o'clock also? Yeah, those are both. 10 a.m.
Your Honor, can I ask about a case real quick?
Sure.
This is the case 369. That's Freedom Management Property Service versus Shepherd.
369. Was it on today's 369? Okay, yeah, Freedom Management. It was an attorney that stood in for attorney Mamat, and he requested an adjournment to the 22nd.
Oh. Okay, and the court granted that?
Yep, so 367 and 369 are both adjourned to May 22nd.
At what time?
10 a.m.
Thank you, Your Honor.
Well. Tony Bragg, come back. The party's ready on Morrow or Williams.
Attorney Boyke,
Good afternoon, Your Honor.
I apologize. We are not ready on Morrow yet. We are still waiting on some more information from opposing counsel. Thank you.
Okay. And what about Williams?
We are ready on Williams, Your Honor.
Okay, calling case number 23345786. This is CV Homes Inc. versus Marilyn Williams, and occupants are Myers.
Sumchit Hart, P69542 on behalf of plaintiff CV Homes Incorporated.
And Tony DeGard, P number 83521 here on behalf of defendant Miss Williams, who's here on the Zoom chat under the Zoom name New.
All right. Hello, Ms. Williams.
And we are happy to report that the parties have come to an agreement. This case is going to be a conditional dismissal. The terms are Ms. Williams is going to pay $400 today to her landlord, and then she's going to have 30 days to pay off the remaining balance owed.
$400 to landlord today?
Yes, Your Honor.
And what's the remainder owed?
I believe about $800. If Ms. Hart has the actual number, that would be good.
Bear with me one second, brother counsel.
It's okay. I'm not going to put any pressure on anyone doing public math on Zoom.
Thank you. I believe that with the court costs, her balance would be 1020.
Okay. Okay. Ms. Williams, is that okay with you? Can you speak up, please, or unmute, actually?
Yes, it is.
Okay, so this, all right. So is it 1020 after the 400 today, or is that 1020 including that 400?
That's 1020 after the 400 today. So the total amount would be $1,420 with a $400 payment today, Your Honor, and then the remainder of $1,020 to be paid in 30 days. Is that correct, Mr. DeGard?
That sounds right to me.
Excellent.
And it's 4B or 4HA?
4B.
All right, 4B.
4B.
Ms. Williams, that means if this isn't paid, then parties can get a judgment and an eviction at the same time. So if it is paid, case is dismissed. Is that your understanding? I think that's it.
I believe she's muted.
Okay. I'm unmuted. Yes, Your Honor.
All right, thank you. And do you give consent to Mr. DeGard to sign your name?
Yes, Your Honor.
All right, thank you. All right. Court is satisfied. Court into this. Good luck, Ms. Williams.
Thank you. Attorney DeGard, I'll prepare the COD and send it over for your signature.
Perfect. Appreciate it. Thank you.
Absolutely. Thank you.
Welcome. All right, recalling. Recalling case number 22393532 Woodridge Senior Village versus Chauncey Newton.
Ready, Your Honor. I don't see Ms. Lamonius. Might still be in a breakout room.
All right, Mr. Gertz, I'll allow you to start from the top if you'd like.
Thank you, Your Honor. Oh, okay. Mr. Lewis, if you could go ahead and unmute your device there.
All right.
All right, thank you, Mr. Lewis. We're picking up where we left off. So we last established, you mentioned that you were very familiar with the Unit 401, right?
Yes.
And then can you tell the court how it is that you're familiar with that in relation to your job?
Well, my first encounter with going to the unit, we were doing inspections, inspection repairs and things of that nature. So I knocked on the door and no answer. I knocked on the door maybe 2 more times and no answer. So I proceeded to open the door because I figured no one was at home. And the chain was on the door. So we hollered in maintenance a couple of times. Then the resident came to the door. He proceeded to start cussing us out, saying, "Who the F is it knocking on my door like that? Why y'all hollering in my damn apartment?" So we proceeded not to go in. We weren't going to go into a hostile environment. So we started to, leave or whatever. And, he just kept on ranting,
Okay, so that was your first interaction. You remember when that was?
That had to be sometime in September.
Okay. Is the name Chauncey Newton familiar to you?
Yes. Yes, it is.
And is that the tenant there at Unit 401?
Yes.
All right. Moving forward from that time in September, can you describe any other interactions you had with Mr. Newton?
Okay. Well, it was an interaction where we were in the shop at building 502 when Mr. Newton came in the shop and proceeded to cuss us out then. When are you MFs gonna, something is wrong with my I think it was his stove or something of that nature. And when are you MFs gonna fix my stove? And I proceeded to tell him, I'm not coming up there because of the way you're talking to us. And then he said he would F us up and we ain't shit. And I mean, just kept on with the profanity and cussing us out, threatening to injure us in all types of nature.
Did you feel threatened?
Oh, most definitely. I felt like I was going to have to defend myself.
And what other than what was being said verbally made you feel like you might have to defend yourself?
He was basically trying to approach us, and I proceeded to tell him he had to back up. Back up, or, you know, I felt like I was gonna have to defend myself, you know.
Okay.
The more we backed up, the more he came forward. And he is a big dude.
Are you familiar with something called the maintenance area at that site?
Yeah, that's where he came into the maintenance area. Yes.
Can you describe to the court what that area is?
That area is where we keep all our maintenance supplies, cleaning supplies. It's where the trash compactor is also, where the electrical room is located, and things of that nature.
And do tenants have access to use
No.
any?
No, not at all. He just happened to come back there. The double doors to the maintenance shop was open because we were back there, and we were cleaning up. I think that was one of the days where we take the trash compactor cans out and bring them back in after they're emptied, and reinstall them on the compactor.
There any other interactions that made an impression in your memory?
In the lobby, you know, it was mostly just profanity and stuff like that. Him getting off the elevator and he just started saying on me. Most of the time, he's intoxicated, and the reason why I know he's intoxicated because you can smell it on him.
Okay. Now, hypothetically, one could walk calmly through an area and just say some curse words kind of under their breath, and I don't think anybody would feel frightened. So can you help us, because we weren't there, help us visualize what that interaction in the lobby was like for you?
It was another very threatening interaction, where we didn't know what he was going to do or what he's even capable of. You know, he makes you feel like he's really going to come at you. I mean, we were even on the elevator with him at one time in close proximity, and he just makes you feel like at any time he may lunge at you or try to punch you or something. You don't know if he has a weapon or anything on him. You know, he wants to go with this, you know, man, he's just a threatening figure to me. He really is. And if I feel like I have to defend myself, I try to remove myself from the situation. But if I have to defend myself, that's what I would have to do, because
Okay.
he's not going to let up.
And let's just make a comparison so we all understand. Do you feel this way about everybody who is a little bit larger than you?
No, I don't feel that way about everybody that's a bit larger than me, because everybody doesn't threaten me like that.
Okay. Any other altercations?
Not right off the top of my head, no.
Are you familiar with the dog? Have you had any interactions with him and a dog?
All of my interactions were before he got the dog.
Okay.
Yeah.
All right. No further questions, John.
Okay, so Mr. Lewis, you indicated that you are familiar with Unit 401 and the resident in Unit 401. Is it fair to say that in early September, when you were headed up there, was the first time you had gone to that unit? Is that correct?
Yes.
Had you seen the tenant beforehand? Had you met him beforehand?
No, I hadn't.
So you didn't know what he looked like, and he didn't know who you were, to your knowledge and belief?
I didn't know who he was. he probably didn't know who I was at the time, but after he seen my uniform, it was an indication that I worked there, that I'm a maintenance guy.
Okay. So you stayed when you got there. Do you remember what time of day that was?
I believe it was sometime during the morning.
During the morning. Okay. And when you got there, you knocked on the door a couple of times and there was no answer. Is that correct?
That's correct.
And then you attempted to open the door, but you said that the chain was locked and you couldn't open the door all the way.
Right.
Okay. And so after the date of that incident, you said that you had had other encounters with Mr. Newton, correct?
Yes.
During those encounters, had he mentioned any other, or let me go back to the first encounter. Do you know what you were there to inspect? Anything in particular? Were you there to inspect something in particular or just inspect the unit in general?
We were there to do repairs from the inspection that occurred a little earlier in that month.
And which repairs were you there to do?
I can't quite remember. I mean, I see so many work orders, but it was some inspections that were found some repairs that were found in his unit that were wrong.
And these were repairs, you knew that there were repairs that needed to be made in his unit because a report had already been generated because he had reported them, right?
No, not because he had reported.
Because someone came in to do an inspection.
Right. It was I believe it may have been a state inspection or something like that.
Okay. And so you all do have the records of the state inspection that was performed before you got there?
I'm sure, yes.
And so in the incidences that you described after that day, where you saw Mr. Newton either in the lobby or the elevator or near the maintenance room, had he brought to your attention any other repairs that needed to be made in his unit?
When he came in the maintenance shop unauthorized, he said he had work orders, but we weren't aware whether he had put anything in or not.
Okay. So it was only during that one time that he told you about work orders. There were no other times where he mentioned that work orders or repairs.
No.
Okay.
Yes, that was at one time.
Okay. So do you have access to when tenants make work orders, or are you just told by a higher up when you need to go fix something?
Yeah, the office staff generates the work orders when the resident calls it in and we go repair.
So you did not receive any other work orders to go to Mr. Newton's apartment?
In all fairness, his apartment isn't physically in the building that I work in, but by us doing all the repairs as far as inspection together, that's the reason why I was over in that building that particular day.
Okay, so normally some other maintenance technician works in his building who would be primarily responsible for fixing things in his unit.
Yes.
Okay, thank you. No further questions.
You're welcome.
Nothing further, Your Honor. Thank you, Mr. Lewis.
Thank you.
Thank you, Mr. Lewis.
You're welcome. Thank you.
Thank you for your patience too.
No problem.
Your Honor, that concludes the number of witnesses I want to call. As far as exhibits go, I know this is summary proceedings, but I just ask the court to consider the exhibits we attached to our response to the MSD. 3 notices of civil infraction, the lease, and the notice to quit.
All right. Thank you, Mr. Gerda. And Ms. Lamonius, who are you expecting to are you?
I am expecting to call Mr. Newton as a witness at this time. Okay, Mr. Newton, I would ask you to unmute your telephone by pressing *6. Mr. Newton, would you unmute your
I'm trying, I
telephone?
got it.
Okay, thank
I
you.
got it.
Okay, Mr. Newton, could you state your name for the record?
Chauncey Terrence Newton.
Okay, thank you. Mr. Newton, what is your address?
3701 Miracles Boulevard, 48201 Detroit, Michigan, 5401.
Okay, Mr. Newton, how long have you been living in that apartment?
Going on in August would be 2 years.
Going on in August. So it's fair to say you moved into that apartment in August of 2021.
Yes.
Okay. When you moved into that apartment in August of 2021, how old were you?
58.
You were 58.
Hello.
Is there any reason, he's muted again, 1 second.
CR6.
Are we hearing some background noise? Because I already have a tough time hearing.
Yes.
I think that's someone else. Mr. Newton, could you unmute again?
Yes.
No, not you, ma'am.
There's one.
Thank you.
Okay.
Mr. Newton, when you moved into the apartment, you were 58 years old, is that correct?
That is correct.
Is there any reason why you were allowed to move into the apartment at age 52, the senior facility?
Yes, I was a victim of a crime, and DHC assisted me in getting this apartment because I have a TBI and PTSD.
What do you mean by a TBI?
A traumatic brain injury. It came from, I got hit over 50 times with a log when I got back from Alaska. I'm a celebrity chef. That's what I do. I open up hotels and restaurants throughout the country. And on my, when I got back to Detroit on my last, on my last assignment, I got robbed on Southfield at Joy Road and beat over 50 times. So I get anxious and paranoid. And that's where that's at. Paranoid, insomnia. So it's very imperative as I got well that I wasn't paranoid, meaning that my surroundings were secure.
Okay, so is that so you're saying that that's why you were allowed to move into this apartment at age 58 because you're classified as a person with disability. Okay, so when you moved into this apartment at age 58 in 2021, were there any repair issues in the apartment at the time?
Yes, ma'am.
Can you describe what those were?
The doors hinges was off. The light in the bathroom and the holes that were in the wall was access for roach infestation. And praise God, I didn't get any bed bugs. The lock on my front door, which you all have the pictures, of, my attorney, it would not even work. When I got in, I was locked in my apartment on 2 different occasions. The first occasion was about 13 hours. And the next occasion was 9 hours. Both of them was overnight where I could not get out of my apartment at all. I called the maintenance guy, Leon, Mr. Leon. He didn't get there till that morning. And then it happened again. And then it took about 4 months to eventually fix it. The garbage disposal and my stove was out. The stove was the main thing because I only had one small eye on the stove. I had no oven, and the small eye was the only thing. After 6 months, my mother passed, and I'm not going into a long story, but I tried to have her for dinner. And so I called Miss Dorsey because I want her for Easter. And this is like the 5th month my stove is off. I done bought electronic stuff to cook out of. Miss Dorsey tells me my stove is not a priority. I still never had anything but okay. All right, let me just wait. Let me just hold on. As I continue down, my vehicle gets stolen. They don't want to be professional and giving AAA any of the information. It takes over 4 months for me to get the checks just simply because they won't answer the phone. Ms. Johnson told me that's not their priority.
Okay.
So this is the people, that's where I'm at.
Okay,
Everything that you asked, I'm sorry, go ahead.
Okay, so Mr. Newton, you described some of the issues that you've been having with maintenance. And
Let
so
me
you
just
had
say one more
someone,
thing. Even the door in my bedroom, the closet, it's a double door. With me going through this cancer thing, it's hard for me to even get this door. They know this door been messed up since I moved here. Now, I just got the doors just all there. I mean, wow.
Okay, we're gonna get back to some of the more repair issues, but have you, has the unit been inspected since you have lived there?
Your Honor, I have to object to this line of questioning.
It was inspected 3 times. One of the first times was by the people were saying it was the state. Then Ms. Johnson came up and inspected. Then that new manager came. She walked right to the front door and she said, "You passed," turned around and walked right out. Ridiculous.
Your Honor, reinstating my objection to this line of questioning. This is entirely irrelevant to termination of tenancy case. Ms. Lemoyne has just indicated we're going to get back to more repairs. How much time are we going to waste this afternoon talking about irrelevant material for a termination of tenancy case?
Your Honor, I would argue that this material is not irrelevant. I have indicated in an
No, go ahead. What's the relevance of it?
I have indicated in an answer that these complaints against Mr. Newton stem from him having unmet repair issues, stem from him being a qualified person with disabilities. It stems from the apartment unit's knowledge of Mr. Newton's disabilities. Mr. Newton had informed, which we will learn through his testimony, had informed the apartment management that he had had several repair issues in his apartment, that he had disabilities, one of which was insomnia, where he is not up, or he is
informed us of that. He's informed us of his physical disabilities. He's informed us of his repair issues already, and we've also heard from 3 staff members, one maintenance staff who said that every time they come to his door, he's cursed them out and denied them. So what else are we going to hear?
Well, I'm next going to ask Mr. Newton about a letter that he wrote to the apartment managers, asking them not to come to his unit in the morning.
Do you have that letter?
I do, yes.
Yeah.
Right, so what do we need to hear about it? Why do we need to hear about it?
We need to hear about it because the apartment management was aware that Mr. Newton is an insomniac, was a victim of a violent crime, and had asked them not to come to his unit in the morning time, to give him a phone call as a reasonable accommodation before entering his unit and attempting to make repairs, because Mr. Newton does have a traumatic brain injury and was a victim of a violent crime, and takes issue with people coming to his apartment unannounced, and that these issues are curable, and the management was very aware of everything that was going on with Mr. Newton.
And Mr. Newton?
Yes, sir.
Did you ever have maintenance approach your door to make repairs?
Yes, the first time they had opened the door, I didn't know what they were here for. They came back the next day and came in the room and did something to the sprinklers, and that was it. There's just this sprinkler in the bedroom. I checked the sprinklers in the bathroom, and that was it. There was no problem. Your Honor, I did never cuss them out. At the first time when they woke me up, yes, I did cuss, but I never cussed at them in the downstairs or in the back way. never did that. They cussed at me and told me they had other SHIT to do, and that why
Okay,
the
Mr.
referral
Mr.
wasn't on
Newton,
the.
okay,
I
okay.
apologize. Okay, go ahead. But I did when they opened up my door. I said, "Who is y'all? Why is y'all opening up my door?" I was shocked. Mr. Jabbar had to come out and say, "This is what they do." I said, "Well, they see the thing on there. Why is they yelling up in my in my house? Why would y'all do that?"
Okay.
I have to pause this. What is the goal of all of this testimony that we're eliciting right now? This is a summary proceedings eviction, and there's a termination. There seems to be grounds for termination. Outside of the argument for notice, that you provided anything that says that I must dismiss this case based on the notice violation, although he did receive notice and an additional piece of paper that outlined the reason why this case is being filed. What is the goal here? Because it seems like this is sufficient expedition to file something else. And that's not what
in the response to the initial complaint, when I also submitted the summary disposition, I outlined that one, yes, that the notice was an issue, but additionally that Mr. Newton has had some repair issues and does have a qualified disability. His disability and the way that he has been relating to management is curable because there are ways to get into his apartment and fix the maintenance issues that he has and still give him reasonable accommodations. Mr. Newton has since this case was filed, has alleged that when maintenance went to enter his apartment, it was during the morning hours and he is an insomniac. I have been attempting to prove or show to the court that the apartment complex is well aware of the disabilities and the nature of the disabilities, Mr.
What does it mean that they went in the morning and he's an insomniac?
He's a victim of a violent crime, and he has.
I understand that. What is the significance of being an insomniac and going in the morning? Is he sleeping in the morning? Is he awake?
He has asked the apartment complex to give him notice via a phone call before trying to enter his apartment, before knocking really loud, before trying to enter without giving him notice. There are times of day that work better for him, given his disability, to allow folks to enter his apartment. There are ways that they can reach out to him and let him know what is going to be happening so that he isn't shocked, so that he isn't combative when someone is walking up on him when he does not expect that to be the case. He has a disability. It's been documented. There's proof of that. And there are ways to work around getting his needs met in his apartment while still respecting what's going on with his disabilities. That's the point of that.
Your Honor, even assuming my client was aware of all that, it still is not relevant. Our case has to do with the disruptions that they've talked about, numerous disruptions. This has nothing to do with repairs, awareness of disabilities, which they're not allowed to ask about.
Your Honor, I would say this has everything to do with that. We did also state early on that we believe that these complaints arise from Mr. Newton's dissatisfaction with the way that his repair issues in his apartment have been handled, and they arise from his complaints about the way that he has been treated with his disability.
He's also cussing the staff out,
which he denies.
He just admitted to.
On one occasion when they entered his apartment without him being aware.
I'm going to, how much time do you need? How much time? How do we safeguard Mr. Newton's Section 8 tenancy?
We can safeguard Mr. Newton's Section 8 tenancy by allowing him time to leave with a neutral reference, We were proposing, so in addition to Mr. Newton's disability, he is also undergoing cancer treatment. He has informed me that he has a procedure next week. We are proposing that Mr. Newton be given at least 30 days to vacate the premises with a neutral reference, and we think that that would be something that he would be able to stick to, given the medical procedures that he is getting ready to undergo.
Is there any objection to a neutral reference? Take the time out of it. Is there an objection to a neutral reference, Mr. Church?
Ms. Dorsey? I wish I could answer that off the cuff, but I just don't know.
Your client just unmuted.
Ms. Dorsey?
Yes.
You just heard the discussion about making a neutral reference if the tenant were to vacate in 30 days.
I don't.
Just listen carefully. Did you hear the discussion thus far?
That he'll be given 30 days to move if we give him.
They're talking about a neutral. What was it, Ms. Lemonius?
A neutral reference that would allow him to keep his voucher.
Okay, Ms. Dorsey, do you want to speak with me in private about whether or not you can give that classification or recommendation, or do you already have an answer?
I'd like to speak to you in private.
Okay, Your Honor, may I have a quick breakout room?
Yes, you may.
Thank you.
You're welcome.
Your Honor, I will be pulling Mr. Newton into a breakout room quickly.
Okay. Do you need me, or can you you got it? I invited you to room 4.
I'm off to 4.
Okay.
Your Honor.
Yes.
Your Honor, my name is Kamisha Webster, and I was there in the meeting when you had called case number 676373. Yeah, I was in there, but I couldn't unmute my phone when I was when you were calling my case.
Okay.
I was there.
Call Mr. Move. Yes. What's her name?
I'm sorry.
Write this number down.
1248
248
289
289
33
41.
3341.
That's the attorney on the other side. If you can get her to set it aside, or I'll set it aside. If not, you're gonna have to file a motion. So try calling her. It's still, we can't get it on the docket today, because really, we're supposed to stop by 4. But if you can get her to agree to set it aside or work something out, then that'll work. If not, come back on Monday and you have to file a motion to reinstate it. But see if she'll do it, or leave her a voicemail and see if she'll grant you that.
Yes, sir. Can you give me that number just one more time? I'm sorry.
No, go ahead. No problem.
Thank you.
She's the attorney for the plaintiff. So that's the landlord's attorney. She can say yeah, and we can bring the case back. If not, you have to motion in court, because I can't work just in your favor or just in her favor. So
yes,
that's the most practical approach. And
thank you.
You're welcome. And the number is
1248 289 3341.
All right. Thank you so much for that information.
You're welcome. Good luck.
Thank you.
You're welcome.
All right, then Ms. Dorsey, you can go ahead and mute yourself again. We're back in court main session.
All right. Let's see, I'll invite Mr. Moniz back in. Okay, and Ms. Lamoni, sorry, I know your client is on the phone. I didn't want to move him first, but
Okay.
I'll move him back in too. All right.
Hello?
Ready, Your Honor?
I'm ready.
I did speak and confer with my client. We'd be willing to agree to do the neutral reference if he does in fact vacate, turn the keys in 30 days, if that's the number that's written in the final judgment. Turn the keys, vacate himself, vacate the personal property so that no writ's needed. He'll get a neutral reference.
Money.
I will ask Mr. Newton, in the breakout room. That sounds okay, but I'm looking at the calendar. Mr. Gerda, is 30 days, is that the 11th of June or is that the 12th of June? The 11th is a Sunday.
It was your request, Mr. Moniz.
Yes, I'm saying, or what day on the calendar are you looking at? 7, 14,
I'm using your
20,
language.
28, 29, 30. So if he could be gone, I will discuss that in the breakout room. And I just want to make sure that we would be agreeing with June 11th.
Well, yeah, the end of June 11th, like June 11th, end of the day.
Okay, I'm going to pull him back into the breakout room and make sure that's okay.
All right.
Thank
you.
Your Honor, I haven't pulled my client out of the breakout room yet, but we are in agreement with those terms.
Hello?
Okay, great. And let's see, I'll pull him out.
I just got him.
All right, can we enter this as a consent judgment?
I'm amenable to that.
For consent, if we can get some signatures, yeah.
Okay, all right. Mr. Newton.
Mr. Newton, can you unmute?
Star six.
Yep, okay, he's unmuted.
All right, first and
Yes,
foremost.
yes, Your Honor.
All right. parties have entered into a consent judgment, whereas Mr. Newton, you agreed to vacate by the end of June 11th. So by June 11th, 11:59, or that the morning of June 12th. So June 11th is your last day, and parties can file a writ of eviction on June 12th. So you basically have that weekend of June, 9th, 10th, and 11th, but June 12th will be a day they'll be eligible to file for a writ of eviction.
Okay.
And upon vacating the premises, they will give you a neutral reference so that you won't lose your Section 8 and you still have your sense of security. You can live somewhere else secure. All right?
Okay. Thank you.
There's some reasonable considerations that I may suggest. Maintain some peace in these 30 days. Did you hear me?
I do hear you, Your Honor.
All right, I didn't hear a response to that.
You say maintain my peace. I say I do hear you. Yes, Your Honor. Yeah.
You try your best to maintain your peace and everyone else's peace. And
there you go.
If you can prevent or refrain from any action that may be controversial, try to do so. Okay. I'm not saying that you controversial.
Yes, sir.
I'm just saying that in the event you say, man, I feel like saying something, just hold off on it for a month.
Your Honor, just on the record, only thing I asked those gentlemen downstairs was, did y'all get a referral? I never cussed that there. So that's all. I hope you understand. I understand we be.
It doesn't matter. It doesn't matter. It's water under the bridge. 30 days, neutral reference. This is a consent judgment. You're represented by counsel. Does your attorney have consent to sign your name on this consent judgment?
He is muted again. Mr. Newton, please unmute.
Okay, Mr. Newton, can Ms. Lamonia sign for you?
Yes, she can.
All right, and thank you both counselors, Mr. Gerda and Ms. Lamonia. This was we got to a point of a resolution, so thank you for your patience. Appreciate your efforts.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Gerda.
Thank you, Your Honor. I'll go ahead and prepare.
Thank you, Your Honor.
And send it to you, Mr. Moniz.
Thank you. You'll send that via email?
Yep.
Okay, appreciate that.
And we'll get that filed promptly, Your Honor.
Okay, you all have a great weekend.
You too.
Thank you. You as well.
Ms. Hart, do we still have one?
Yes, Your Honor. Yes, I do.
I was wondering, I thought you were just hanging out to see the result of the hearing. All right.
Yeah, Your Honor, it's like live TV.
Yes, it is. Let's see. Is this Felicia Morrow?
Correct.
Okay. Calling case number 2334-6354, Brentwood versus Felicia Morrow and all occupants.
Good afternoon, Your Honor. Subject Hart, P69542, on behalf of plaintiff Brentwood.
Your Honor, Elise Mikey, P84955 with Lakeshore Legal Aid. I am appearing on behalf of the defendant, who I will be representing. I believe she is in the courtroom right now. So, ma'am, if you are present, please unmute and state your full name.
My name is Felicia Nicole Morrow.
Thank you, Ms. Morrow.
Your Honor, I've been in communication with opposing counsel throughout the afternoon. I understand, there are, I suspect, a lot of cases that are being adjourned. However, this case we do.
I'll grant the adjournment. I'll grant the adjournment.
Thank you, Your Honor. I think we could probably get this resolved before our next court date anyways. We just need to share some documents.
A brief adjournment, Your Honor.
That's fine with us.
Let's just keep it. My goal is to keep everything in May because June, we go back in person June 5th. And the dockets change and I get first hearing. So I just don't want to throw off the docket before we get the docket. So pick a date in May that's not the 18th or 19th, and we're good.
That up. Attorney Hart, do you have?
What, preferably Tuesdays and Fridays?
Yes.
Your Honor, you said not the 18th or 19th, correct?
Correct.
The 17th, Your Honor.
All right. Can you work with that, Ms. Boyke?
That's not my usual day to be in court, but I can be there for that. For sure.
Okay. All right. Okay, we'll go. I'll see you all back May 17th. That's brief. You sure? Want to go? Okay, all right, that's fine.
I think that should be sufficient. What time, Your Honor, should we be back on that date?
10 a.m.
Okay.
Excellent, Your Honor.
Attorney Hart, I will send you some documents and we'll just communicate early next week.
Absolutely. Absolutely. Thank you, Attorney Boyke. Thank you, Your Honor.
You're welcome. You all have a great weekend.
Thank you, as well.
Thank you, Your Honor.
But what
Thank
better
you, Your
way
Honor.
to spend a Friday afternoon when it's 80 degrees outside, in your virtual courtroom?
I agree. I mean, it looks comfortable wherever you are. At least you're outside.
Yeah. Thank you, Your Honor.
It gets hot, so the longer in the day, it's just.
All right. Goodbye.
Bye. Thank you, Ms. Boyd. And Tony Bragg never came back. Mr. Bragg. Yeah. May 17th. All right. Calling case number 233466261. This is Tony Bragg versus TR Roby. The court finds good cause to adjourn this matter to May 26th.
May 26th, I believe so, Judge. Yep. 60.
Okay. To May 26, 2023, to effectuate proof of service. Court is not in receipt of proof of service, and we were unable to track it down. However, a dismissal is the most draconian decisions. So, well, maybe not the most, but in this circumstance, it would be. And we'll hold off on doing that and give Mr. Bragg one more shot at the proof of service. All right, that concludes the docket. Friday, June 12th. Thank you, everyone.
Thank you, Judge. Have a good weekend.
All right, everyone have a good weekend.
Enjoy
Thank
the
you, Mr.
weather.
Yes, please
I
enjoy
know-
the weather.
I know you can't see from the courtroom, but kind of overcast now. It was beautiful this morning.
It was hot at lunch, so it's like 82 and mostly cloudy based on my information bar. It's Windows, computers.
Hello?
All right, see y'all.
All right.
Hello?
Oh.
Hello?
Hello? Hello?
Yeah. Yeah.
Yes, it's Miss Bridges calling. Did you call Amy Bridges?
I called everybody, ma'am.
I didn't hear my name called. I've been on the phone since this morning.
What's your case number, Ms. Bridges? Ms. Bridges, what's your case number?
It's upstairs. I'm outside.
All right. It's the end of it's 4:25, Ms. Bridges. Zoom in on Monday. Because your case is not gonna get processed. We don't have any staff here anymore.
Oh, okay, you shall come in Monday?
Yeah, call in on Monday.
Okay, to your courtroom?
Yes, ma'am.
Okay, thank you very much. I appreciate it. Enjoy your weekend.
All right, enjoy your weekend. God bless you.